Good morning and welcome to the 12th meeting in 2025 of the Local Government Housing and Planning Committee. And I remind all members and witnesses to ensure their devices are on silent. Our business this morning is consideration of the Housing Scotland Bill at Stage 2, Day 1. And I welcome to the meeting the Minister for Housing, Paul McLennan, MSP and his officials. And we're also joined by other members of the Scottish Parliament who have lodged amendments to the bill and are present to debate those with us today. And I will briefly explain the procedure we will be following during today's proceedings for anyone watching. Members should have with them a copy of the bill, the marshalled list and the groupings. These documents are available on the bill webpage on the Scottish Parliament's website for anyone observing. I will call each amendment individually in the order of the marshalled list, and the member who lodged the amendment should either move it or say not moved when it is called. If that member doesn't move it, any other member present may do so. The groupings of amendments set out the amendments in the order in which they will be debated, and there will be one debate on each group of amendments. In each debate, I will call the member who lodged the first amendment in the group to speak to and move that amendment and to speak to all the other amendments in the group. I will then call other members with amendments in the group to speak, but not to move their amendments, and to speak to other amendments in the group if they wish. And I will then call any other members who wish to speak in the debate. Members wishing to speak should indicate clearly by catching my or the clerk's attention. I will then call the Minister if he has not already spoken in the debate. And finally, I will call the member who moved the first amendment in the group to wind up and to indicate whether he or she wishes to press the amendment or withdraw it. If the amendment is pressed, I will put the question on the amendment, and if a member wishes to withdraw an amendment after it has been moved and debated, I will ask whether any member present objects. If there is an objection, I will immediately put the question on the amendment. Later amendments in a group are not debated again when they are reached. If they are moved, I will put the question on them straight away. If there is a division, only committee members are entitled to vote. Voting is by a show of hands. It's important that members keep their hands raised clearly until the clerk has recorded their names. And if there's a tie, I must exercise a casting vote. The committee is also required to consider and decide on each section and schedule of the bill and the long title. I will put the question on each of these provisions at the appropriate point. We will not dispose of any amendments beyond the end of Part 1 of the bill today, and will now begin. I call Amendment 203 in the name of Rachel Hamilton, grouped with amendments as shown in the groupings, and I remind members of the preemption and direct alternatives in this group as set out in the groupings. Rachel Hamilton to move Amendment 203 and speak to all amendments in the group.
Thank you, Convener. For transparency, on these amendments in particular, I worked with a leading membership organisation who work with hundreds of property agents called Property Mark. Amendments 203, 204 and 205 make changes to require the reports to be submitted to ministers on a specified date. As currently drafted, the bill requires all local authorities to assess rent conditions in their area and submit a report to Scottish ministers at least every 5 years. The first report must be completed by the 30th of November 2026. However, this risks the scenario where all 32 local authorities in Scotland will be working to their own timeline and reporting at different times. Therefore, to help tenants and landlords understand when the designation of a rent control area will take place, local authorities should be required to submit their reports on the same date. This will ensure that the periodic assessment of rent conditions by local authorities are consistent. Amendment 203, 4 and 5 seek to improve transparency, ensure consistency across local authorities in Scotland and make it easier for the Scottish Government to assess national trends and take informed action where needed. Amendment 204 is consequential to Amendment 203. and so is Amendment 205, a consequential to Amendment 203. Amendment 206 aims to bring greater clarity and consistency on the designation on rent control areas for landlords and local authorities. As currently drafted, the designation of a rent control area is open-ended, meaning that it can be interpreted and applied by local authorities differently across Scotland. To help tenants and landlords understand rent control areas, Amendment 206 requires local authorities to specify the rent control area by reference to the street or ward. This would ensure that rent control areas are clearly defined, easily understood, and that implementation is more consistent. To speak to some of the other amendments in the group on the rent control areas, in the name of Megan Gallagher, her Amendment 133 seeks to ensure that there is a layer of protection for areas where rent control is introduced in rural areas. So too in Amendment 133, similar to amendment which would strengthen the bill to ensure that rural impact is considered. On Amendments 81, 82, 83 and 84, they seek to change the reporting period of assessing rent controls by each local authority area from 5 years in the bill. It's originally drafted to either 4, 3, 2 or 1 years, respectively. And finally, in this grouping, convener, Amendments 94, 95, 96 and 97, which are powers to designate a rent control area, they basically seek clarity around the expiry period of 5 years to either 4, 3, 2 or 1 years, respectively. And I will move my amendments in my name. Thank you.
Thank you. I call Megan Gallagher to speak to Amendment 133 and all other amendments in the group.
Thank you, Convener. 133 creates, as Rachel Hamilton said, a layer of protection for areas where a rent control is introduced in rural areas. An assessment would be conducted within the local authority area to highlight the level of impact that the rate of rent of increase in rent payable under the relevant tenancies of properties has on those properties, tenants and landlords. The needs of rural Scotland must be placed front and centre by the Minister as they seek to change the PVI sector. The Minister, of course, will be aware that rented housing is vital to many of our rural economies, particularly when attracting workers to an area for tourism, farming, forestry and other seasonal sectors. The debate on rent controls, in my view, has been quite urban focused, and this needs to change. These communities could be at real risk should the Scottish Government fail to take these important sectors into account. And I believe that Sarah Jane Lang, Chief Executive of Scottish Land and Estates, has summarised it well when she says that between the start of 2022 and the end of 2023, across 18 local authorities with rural areas, 11 saw decreases in the number of properties available for rental. With the Scottish Government now seeking to move forward with rent caps, it needs to fully understand the further detrimental consequences that this could have on rural rented provision before bringing forward Stage 2 amendments. Therefore, I asked the Minister in relation to 133 what specific engagement he has had with rural housing stakeholders on this issue and whether he would be inclined to support my amendment, which I believe strengthens support for rural communities. Similar to 133, and my amendment number 90 relates to strengthening the bill to ensure that rural impacts are considered and circumstances that can be addressed within the Scottish Government's guidance. And I'd be keen to have discussions with the Minister on that to see if there is a way that if this is not passed today, if we could look at making sure that this is covered within the guidance of relating to the bill. And amendments 181 to 184, the bill requires local authorities to make periodic assessments of their rental markets, and the Scottish Government is seeking to amend this from the 30th of November 2026 to the 31st of May 2027. The policy replaces the current option for local authorities to make rental assessments for the purposes of requesting Scottish ministers with a rental pressure zone, with a mandatory requirement that local authorities must make rental market assessments and recommendations, whether they proceed with the creation of a rent control area. Many stakeholders are, of course, concerned about the issue of effective and robust data collection, as this remains an obstacle to local authority private rental market assessments and reports. My amendments here seek to change the reporting period of assessing rent controls by each local authority area from 5 years in the bill as originally drafted to 432 or 1 year respectively. I believe that 5 years could be extensive when looking to report on the impact of rent controls and seek further discussions with the Minister to look at reducing the original timeframe. Amendments 94 to 97. Again, I'm seeking clarity from the Minister on this particular amendment to find out why he has opted for a 5-year expiry date unless of course revoked, and what consultations he has undertaken with the PVI sector on expiry and reporting periods. I will end my contribution there just now, Convener. Thank you.
Thank you. Minister to speak to Amendment 278 and other amendments in the group.
Thank you, Convener. Amendments excuse me, 203, 204 and 205 in the name of Rachel Hamilton would change the requirement that local authorities submit a report on their assessment of rent conditions to be the Scottish Ministers by the end of a specified reporting period. Instead, local authorities would be required to submit those reports on a particular date. I am clear that the bill as introduced offers greater clarity and increased flexibility, enabling local authorities to submit reports in advance of deadlines if they wish. Amendment 133 in the name of Megan Gallagher would require local authorities to include in their assessment the specific impact on rural areas. I recognise the importance of having the fullest understanding of the impact of rent levels on specific groups of landlords, including those in the rural sector. However, the existing requirements already require local authorities to assess rent levels and the rate of rent increases in the area. Where rural properties are a feature of local authority area, this will be reflected in the assessment, and this amendment is not considered necessary. But I'll touch on the points that you mentioned, Ms Gallagher, just later on there. I've engaged with SLE on a number of occasions on this particular point, and obviously encouraged them to take part in the consultation. As Ms Gallagher may be aware, a consultation to support the consideration of the use of powers in the bill in relation to exemptions and circumstances where rent may be increased above the rent cap was recently published. This presents an opportunity for all those who will be affected to input their views. For those reasons, I cannot support this amendment and would encourage Megan Gallagher not to press it. However, happy to engage on that particular point. And again, I'll touch on your specific Amendment 90 just in a minute or two. Amendment 278 in my name amends the date for local authorities to submit their first report to the Scottish Ministers on their assessment of rent conditions from the 30th November 2026 to the 31st of May 2027. Now, we recognise that the current timetable in the bill for local authorities to submit their first assessment report is challenging. Moving the date for local authorities to submit their first report is considered necessary to allow sufficient time for assessment and reporting to be completed. We continue to work collaboratively with local authorities. The later date for reposting will not prevent local authorities from starting their assessments as soon as Part 1 takes effect. I would urge a member... Yep.
I'm sorry, I missed to intervene on you when you were discussing 203, but it is relevant to what you're just talking about. Obviously, there are rental properties managed by property organisations across Scotland having to deal with a lot of different local authorities. How can the tenant and landlords, of course, but how can tenants and landlords understand when the designation of a rent control area will take place if local authorities are not consistent in their approach? Surely that doesn't lend itself to good business practice and understanding, the consistency and clarity that they actually need. And that will obviously grow the economy and protect jobs and also ensure that they stay in the market and don't actually come out of the market because of all this confusion.
I think there's a number of things. One, obviously, we've discussed this with local authorities in terms of that, and I think one of the key things they were talking about is having the flexibility to submit the report in advance of the debate. One of the key things, I think, for me, and the point that you raised, I think is relevant, is in terms of obviously the communication around about the dates, which I think is up to each individual local authority. I think there's also, in terms of we're getting the reports all in at the same time, I think it might impact on the speed in terms of how we deal with these as well. But I take on board the points that you mentioned, but that was something that we spoke to local authorities about in that regard. And in regards to the flexibility in submitting the reports in advance of that.
Are you saying, because I just need to be clear on this, are you saying that that government are going to encourage local authorities to submit reports at a fairly similar time, or what is your encouragement? Is it just an encouragement? Is that what you're going to say to them rather than putting it into legislation?
I think it's that in terms of the flexibility, I think that's something that gives the local authorities had asked for on that particular point. So we would encourage the local authorities to be as timid as they possibly can. But they did ask, in terms of some of the feedback, it's in terms of giving them the flexibility rather than being a specific time. I think also in terms of all the reports coming in the exact same date would obviously impact on the speed in designating areas for rent control. So it's trying to ask them to be as timid as possible. But they did ask for the flexibility around about that particular point.
Right.
Can I just remind members that we're following a debate style, so let's try not to... Interventions are welcome at members' discretion, but let's try not to get into a question-answer back and forth going forward. And Rachel Hamilton will be given a chance to wind up.
Yes. Yeah.
I thank the Minister for giving way there, and it's to follow up on the points that Rachel Hamilton has raised, because the Minister will also be aware that landlords don't just operate in one local authority area. Of course, you'll find that they'll operate in maybe 1, 2, 3 or how many local authority areas in which they have properties. How do you think that's going to work if local authorities are not producing these reports at the same time? And what additional strain will that put actually on the housing sector in terms of the PVI, in terms of our landlords, who will obviously have to provide that data to local authorities in order for them to produce those reports?
Again, I think the point was raised as a valid point in terms of that. I mean, I'm happy to engage a lot further in that particular point. We did react to the flexibility that was asked for local authorities. I'm happy to engage and come back on that particular point that you've mentioned on there. So I'll keep on going, convener, in terms of amendments. Just check where I am in terms of amendments 81, 82, 83 and 84 in the name of Megan Gallagher reduced the local authority assessment period from 5 years down to 4, 3, 2 or 1 years respectively. Now, whilst I recognise Megan Gallagher's desire to ensure frequent assessments of rent conditions, these amendments result in assessments being conducted more frequently than is necessary and would increase the workload and cost on local authorities. The bill sets out any designation of a rent control area that will apply for 5 years. This is intended to allow a sufficient period for rent levels to stabilise, provide certainty for landlords and tenants. The 5-yearly assessment process supports this approach. The bill provides a number of checks and balances to ensure the continuing proportionality of rent control. The Scottish Ministers will be under a duty to keep the operation of rent control areas under review to ensure they remain proportionate. This will include a duty to revoke regulations earlier if no longer proportionate. Local authorities will be able to carry out an interim assessment of rent conditions in their area where they consider there has been a significant change in circumstances. There are also powers for the Scottish Ministers to direct a local authority to undertake such an interim assessment. These provisions will ensure that rent controls remain in place only where it has been demonstrated to be necessary in connection with the purpose of protecting social and economic interests and tenants in these areas. I would therefore urge Megan Gallagher not to press these amendments. Amendment 482 in the name of Carol Mockin would change the powers in the bill which would enable ministers to change the periods in relation to which local authorities must submit reports on their assessment of local rent conditions. This amendment would prevent ministers from extending the period between each local authority report beyond 5 years. I recognise the importance of ensuring that local authority assessments are undertaken at regular intervals, and I'm committed to this being on a 5-yearly basis, but allowing for an adjustment to the time period in unforeseen circumstances is considered essential. I believe that the Amendment 480 is unnecessarily restrictive and would urge Carol Mockin not to press this amendment. Amendment 206 in the name of Rachel Hamilton would require local authorities to specify areas which are recommended to be designated as a rent control area by referring to the street or ward. This would be in addition to the requirement to delineate the area of the plan. Requiring both could cause confusion when a recommended area included only part of a street or ward. Whilst I do recognise the importance of ensuring that rent controls are clearly defined, the powers in the bill already allow for this. For this reason, I would urge Rachel Hamilton not to press this amendment. Amendment 90 in the name of Megan Gallagher would require the Scottish Ministers to consult persons who pair to them to understand the impact of rent increases in rural areas before issuing guidance to local authorities about the carrying out of assessments of rent conditions. This would be in addition to the existing broad requirement to consult with local authorities and representatives of landlords and tenants' interests. I have concerns this amendment would require members to consult every person who appears to them to understand the impact of rent increases on rural areas, which does not appear beneficial unnecessary. Understanding impact is also entirely subjective. But as I mentioned previously, I'm happy to engage with the member in that particular regard, and having had discussions with SLE also, so I can pick that up with Ms Gallagher on that particular point. I recognise the importance of the underlying principle of this amendment, and I'm committed to engage with the sector as the bill progresses. I cannot support Amendment 90. The stage of urging Megan Gallagher not to press it. Amendments 279 and 280 in my name allow for the consultation requirements in relation to guidance and local authority assessments of rent conditions and local authority reports, respectively, to be met by consultation carried out before these requirements come into force. Consulting before these requirements come into force will support bringing forward the guidance as soon as possible. I would therefore encourage members to support my amendment 279 and 280. Amendment 142 in the name of Edward Mountain would oblige the Scottish Ministers to issue guidance to local authorities about reports which are prepared following their assessments of local rent conditions. I am clear that there is a need to provide guidance to local authorities, and whilst I believe the power in the bill is sufficient, I will support Amendment 142 in the name of Edward Mountain. However, I would look to amend the duty at stage 3 to allow time for consultation before any such guidance is issued. Amendment 143 in the name of Edward Mountain would require the Scottish Ministers to include in guidance to local authorities eligible reasons why a local authority can make recommendations about rent control when reporting about their assessment of rent conditions. The assessment process is intended to ensure local authorities can consider conditions that are relevant in their area and reach their own conclusions about the need for rent control. Having an exhaustive list of reasons for recommending rent control would be restrictive and may not support local factors being brought into consideration. Whilst I cannot support this amendment, I would offer to work with him ahead of stage 3 to fully understand the intent behind his amendments with a view to informing the guidance which we all recognise is so important. On this basis, I would urge Edward Mountain not to press Amendment 143. Amendments 144, 145 and 146, namely Maggie Chapman, would collectively remove the Scottish Minister's discretion in the rent control process, where the local authority recommends that all or part of the area is designated as rent control area. Ministers would be under a duty to designate a rent control area if that was the recommendation of the local authority. That duty would apply even if ministers considered that the rent control area was not supported by evidence or that rent control was not necessary or proportionate. I understand Maggie Chapman's desire to ensure that the recommendation of the local authority is given due consideration. I cannot, however, support these amendments and believe that the Scottish Minister's duty to consider the necessity and proportionality of rent control should apply to the decision about whether to designate an area as a rent control area. I would therefore encourage Maggie Chapman not to press amendments 144, 145 and 146. Amendments 94, 95 and 96 and 97 in the name of Megan Gallagher would reduce the period of regulations designating an area as a rent control area from 5 years down to 4, 3, 2 or 1 year respectively. The overarching purpose of the rent control measures is to stabilise rents in areas where market rents have been increasing particularly steeply. We consider that reducing the length of time in a rent control area can be in place would reduce the overall effectiveness of the measures in meeting this purpose. Sure. Yep.
Can I ask the Minister what work has been undertaken in that field to know that it's 5 years? Because again, one of the main issues with rent controls and the reason why stakeholders have been so concerned about permanent rent controls is the lack of data analysis and work that's been undertaken in this field to know exactly what the impacts are going to be in Scotland. So can I ask, what impact assessments have been done by the Scottish Government to arrive at 5 years?
I think in terms of the feedback from the sector, I think I mentioned it about previously about looking at sufficient time for rent levels to stabilise, and that was always providing certainty for landlords and assess uncertainty on that particular point. And I think the 5-year assessment allows us to do that. I mean, obviously, we've engaged with the sector previously through the PRS review group that's there, and there's also the consultation process that's on at the moment. So that will continue to do that throughout the process. I'll try and find my place again. Apologies. So I think I think it's in about 94, 95, 96 and 97. Shorter periods, I think, for rent control to be in place could also create uncertainty for landlords in terms of that. And I think I'd mentioned around about whether more frequent decisions or not would apply in the area. The bill provides a number of checks and balances to ensure the continuing proportionality of rent control. Scottish Ministers, as I said, will be under a duty to keep rent control areas under review to make sure that they remain proportionate or to vary or revoke the regulations if they are not. This approach allows for a shorter duration of rent control where this is appropriate. I would therefore urge Megan Gallagher not to press amendments 94, 95, 96 and 97. Amendment 69 in the name of Graham Simpson would oblige local authorities to establish rent boards regardless of whether there is a rent control area within that local authority's area, even though only they would have functions where there is a rent control area in that place. While I agree with the importance of monitoring the operation of any legislation, establishing 32 local authority rent boards would be costly and arguably disproportionate, given that some local authorities may not have a rent control area in place at a given time. Many of the functions of the rent boards set out in the amendment already provided for in the bill. Section 11 of the bill requires ministers to keep rent control areas under review. The bill also includes regulation-making powers which allow ministers to specify properties which should be exempt from rent control or circumstances in which a modified rent cap should be applied. The bill would require the Scottish ministers to consult before these powers are used, and regulations under these powers would be subject to parliamentary oversight. There would not be the same level of scrutiny applied to the functions of a rent board. I note the intention that rent boards should support tenants with any appeal to the rent officer or first-tier tribunal. While these processes are designed to be accessible, I recognise the intent of Graham Simpson's amendment and will continue to consider best how to support amendments, and we'd be happy to engage with them in that particular respect. However, I do not consider that creating another statutory body is the best approach to delivering this. For all these reasons, I cannot support the amendment and would urge Mr Simpson not to press it. Therefore, I would urge Rachel Hamilton, Megan Gallagher, Carol Malkin, Maggie Chapman and Graham Simpson not to press amendments in this group, and for Edward Mountain not to press his amendment 143. I would urge the committee members to support amendments 278, 279 and 280 in my name, and amendment 142 in the name of Edward Mountain. If pressed, I would urge the committee not to support Rachel Hamilton, Megan Gallagher, Carol Malkin and Maggie Chapman amendments in this group, and amendment Edward Mountain's amendment 143 for the reasons I've set out. Thank you, Convener.
Thank you. Carol Mochan to speak to Amendment 480 and other amendments in the group.
Excuse me, thank you, Convener. Can I just draw people's attention to my register of interest where I previously owned rented property? I'm happy to speak to the amendment lodged in my name. All my amendments seek to strengthen the capacity of local authorities to assess rent conditions in their area. Amendment 480 adds a requirement that by regulation prevents Scottish ministers from increasing the time period by which local authorities submit reports for a periodic rent assessment. Amendment 480 seeks to optimise the time span of information collected by local authorities and to increase the accuracy this presents in the medium to long term. The amendment enables a Scottish minister to change the intervals by which information about rents are shared by a local authority. However, importantly, it limits the minister from increasing this reporting over the 5-year range that is currently proposed. In short, this would ensure that data collection will not be allowed to increase to 6, 7 or 8 years, for example. I note that other amendments limit the frequency of reporting to not more than once per year. This, in my view, is reasonable, but my amendment makes sure that the 5-year range remains optimal, which will ensure an accurate national picture over time, something that does not exist in Scotland yet, but once initiated should be maintained and is an important amendment. Thank you, Convener.
Thank you. Edward Mountain to speak to Amendment 142 and other amendments in the group. And as Edward isn't present at the moment, I believe Megan Gallagher is going to speak to those amendments.
Thank you, Convener. And if I may start by thanking the Minister for agreeing to support Edward Mountain's Amendment 142. I do believe this is a step in the right direction, that Scottish ministers must issue guidance to all local authorities about rent condition reports. Again, it's a way to strengthen the bill, and I will therefore push that amendment on behalf of Edward Mountain this morning. And in terms of Amendment 143, as the Minister has pointed out, this amendment relates to guidance, including provisions about eligible reasons for rent controls. I do believe that this is a sensible amendment to look at the scoping for why rent controls may be brought into specific local authority areas or right across the board, as the case may be. And I think we really do need to tease out some of the reasons why rent controls may or may not be brought in. So I think Edward Mountain would welcome the opportunity to work with the Minister ahead of stage 3. I think that's all I've got to say on those amendments, Convener. But before I finish, if I may just raise a concern this morning regarding the lack of attendance from members who do want to be here, given the fact that we do have two committees that run at the same time. This, of course, has led to Edward Mountain not being able to attend the committee, and I do hope, I know we're talking about the processes and the functionality of committees at the moment, but if we do have the Heating Buildings Bill, for example, reach this committee, that of course will have a very heavy focus on net zero energy that relates to the other committee that's running at the same time. So I'm hoping that this could be reflected this morning, because there are members who do want to attend this committee and speak to their own amendments. Thank you.
Thanks very much for that comment. Maggie Chapman to speak to Amendment 144 and other amendments in the group.
Thank you very much, Convener. And if I may just take a little bit of time to talk a little bit about this bill overall. But before I do that, can I express my thanks to the Ledge team, to the Minister, MSPs from other parties and organisations who I know we've all had lots of conversations with over the last many months. I'm proud that we're here discussing amendments to the Housing Scotland Bill. It was, of course, introduced by my Scottish Green colleague, Patrick Harvey, as part of our work with the Scottish Government to deliver a new deal for tenants. That bit is key, so I'll repeat it. This is part of a new deal for tenants. That was the point of this legislation, to make living more affordable, healthier and happier for renters, to make renting safe and secure for those who choose to rent, as well as for those who have to rent. To make renting not just something that landlords profit from, but to ensure that it is viable and non-stigmatising as a part of our housing system. It is for renters that this bill exists at all, to tackle unchecked soaring rents that they've been subjected to for far too long, to give them rights to make their homes really feel like their home, to provide protections against homelessness, and to give specific groups of tenants, such as students, protections against rip-off rents, and to make housing fairer for them. So it is with renters in mind that we've lodged the amendments that we have and that I'll speak to today. Turning to my amendments 144, 145 and 146, these establish a simple but important principle that the Scottish Government should respect local decision-making on rent control areas. At the moment, an application for a rent control area can simply be vetoed by the Scottish Government by not acceding to a request to designate a zone or not make a decision on it. The Verity House Agreement, signed by the Scottish Government, says, and I quote, "The powers held by local authorities shall normally be full and exclusive. They may not be undermined or limited by another central or regional authority." End quote. So with all due respect to the Minister, I don't see how a government which signed up to that principle can then give itself an unchecked right of veto, however unintentionally. I think and I hope that this is simply a drafting issue. My amendments suggest a compromise, a way to deal with this issue. They require the Scottish Government to introduce the rent control area suggested unless they bring a motion to Parliament not to do so. So what the Minister says, that this removes Ministers' discretion, is not actually the case. Rather, it respects local decision-making whilst guarding against any unlikely scenarios where the rent control area proposed is fundamentally flawed. And that is very, very specifically what Amendment 145 does. It gives ministers the power to say, no, not at this time, we need to do that, but to do that in a democratic way through Parliament. Turning to other amendments in the group, I would question why the Minister's Amendment 278 kicks the can further down the road by ensuring the process starts another 6 months later, the process having already been delayed on more than one occasion. In terms of the timing of the process, I support Carol Mochan's intent in 480 to ensure that local authorities need to look at bringing in rent control areas at least every 5 years. Doing it more frequently than that and limiting the lifetime of RCAs, such as Megan Gallagher's amendments suggest, I think would add too much uncertainty for both renters and landlords and severely overstretch local authorities. Whilst we can't support all of the Conservative amendments in this group, they do have a number of other helpful amendments, such as Rachel Hamilton's 206, which will help us be clearer about how we draw the boundaries of rent control areas, and Graham Simpson's 69 on the establishment of rent boards. While I have a couple of questions about the powers and responsibilities of these boards, I think the principle is sound and we support Amendment 69. And I'll leave my comments there. Thank you.
Thank you. And Graham Simpson to speak to Amendment 69 and other amendments in the grouping.
Well, thank you very much. And of course, it's always good to have the support of my good friend Maggie Chapman as I prepare to speak to Amendment 69. My approach to this bill has been to accept the parliamentary arithmetic that we are going to have rent controls and to work to achieve the best possible system of rent controls. Even though my party is opposed to rent controls, I think, you know, my approach is to, you know, hopefully get the best system that we possibly can for tenants and for landlords. Convener, you're well aware of the important work that the cross-party group on housing has done over the years, because you're deputy convener of that group and I'm convener. And in 2022, we produced a very detailed report on rent controls, because there are a number of different systems used throughout the world. And I was very pleased to write a foreword to that report. Now, in some parts of the world, and San Francisco is a very good example, rent boards are a feature of their system. I have to say San Francisco is not a good example when it comes to homelessness, because it has a terrible problem with it. But there, the rent board protects tenants from excessive rent increases and unjust evictions, while assuring landlords get fair and adequate rents. And for me, having a rent board in each local authority area creates a one-stop shop for people. They know where to go. And remember, if you accept that we're going to have rent boards, then we should make it the best system that we can. So Amendment 69 says that rent boards should be established and sets out their functions. Currently, we have the Rent Service Scotland, and I bet that most people have never heard of the Rent Service Scotland, let alone know how to use it. This committee has heard about the difficulties that tenants face in exercising their existing rights, leading to low take-up of the right to rent adjudication by Rent Service Scotland, actually making the point that I've just made. So this amendment creates a new system. I accept that that may be a new idea for some members, but I would argue it's worth looking at, maybe not at this stage, but perhaps for stage 3. The Minister, in his usual style, has offered to talk about it. I'm happy to talk about it. I accept that the amendment as drafted, it could be onerous, it could be costly, but I hope I've managed to explain what I'm hoping to achieve here. It's a local system, and I'll take the Minister up. I have to say, there was a bit of a gasp when the Minister accepted Edward Mountain's amendment. The first opposition amendment he's accepted of the day. I hope it's not the last, and I'll leave it there. Thank you.
Thank you. Would any other members like to speak? Okay. Rachel Hamilton, to wind up, and press or withdraw Amendment 203.
I'll press Amendment 203, Convener. I am slightly disappointed that the Minister is not minded to support most of the amendments, but obviously has committed to Edward Mountain's Amendment 142, which changes the words slightly to create some clarity. I also understand his comments around some of the comments that he's made around ensuring that local authorities have flexibility. I think that is really important, because we accept that local authorities want to be flexible, and we're supportive of encouraging that autonomy. I understand also Maggie Chapman's concerns around being overburdensome towards local authorities, but thank her for her support on 206. I think it's really important that we recognise that consistency in a local authority approach is essential to driving the local economy, particularly in rural areas where Megan Gallagher has eloquently set out, why we should support areas that she set out. I also think improving data collection is really important, and giving the rental sector confidence, which has been lacking lately, and we know that the impact of some of the legislation has affected the sector. So I do do think it's reasonable to ask for clarity and consistency. It's very important when it comes to rent control assessments, rents and designation. Yes, of course.
I thank the member for taking the mention. I think you're making a very valid point, Ms Hamilton, about the necessity for local authorities to have that flexibility and also to ensure that rural areas, as you've already identified, are given that opportunity, because they are going to be marginalised potentially, as already we've heard. So I think that the point you make is very valid about ensuring that we have that consistency, the timescale and the robustness that needs to be put forward.
Yeah, I thank Alexander Stewart for the intervention, because whilst we don't want to be overburdensome, we want to offer flexibility, as the Minister said, but I think it's about offering, and it's our job in this place to make sure that there is a consistent approach, whilst recognising that we don't put too much burden onto local authorities. But it is really for the economy and the jobs and the sector that we all want to see improvements. I can hear that in this room. I do also recognise that the Minister has, on some of the amendments, said that he will work with myself and my colleagues and others. So I thank him for that. And that's all I have to say. Thank you, Convener.
Thank you. The question is that Amendment 203 be agreed. Are we all agreed?
No.
No? Thank you. We're not agreed. There'll be a division. Those in favour of Amendment 203, please raise your hands. Those, got it? Those against? I think that's everybody. Yeah. Got it. And, okay, so that's it. Don't need to ask about that, right? I can leave that. Okay. The result of the division for Amendment 203 is 4-3. 4-3 against 4, and there were no abstentions. The amendment is therefore disagreed. Call Amendment 133 in the name of Megan Gallagher, already debated with Amendment 203. Megan Gallagher, to move or not move?
Move.
The question is that Amendment 133 be agreed. Are we all agreed?
No.
No. Okay. We're not agreed. There will be a division. Those in favour of the amendment, please raise your hands. Okay. And those against? No abstentions. Okay. Who's doing the marking? Yeah, no abstentions. The result of the division on Amendment 133 is 4-4 against 3. What does that mean? That means the amendment is therefore agreed to. I call Amendment 204 in the name of Rachel Hamilton, already debated with Amendment 203. Rachel Hamilton, to move or not move?
Not moved.
Not moved. Okay. Just move on here. Call Amendment 205 in the name of Rachel Hamilton, already debated with Amendment 203.
Not moved.
I remind members that if Amendment 205 is agreed to, I cannot call Amendments 278, 81, 82, 83 and 84 due to preemption. Rachel Hamilton, to move or not move?
Moved. I will move that then.
Move.
Yeah.
Where's my next bit? The question is that Amendment 205 be agreed. Are we all agreed?
No.
No. We're not agreed, therefore there will be a division. Those in favour of Amendment 205, And those against? Okay, thanks. The result of the division on Amendment 205 is 3 for, and 4 against. Therefore, the amendment is disagreed. Call Amendment 278 in the name of the Minister, already debated with Amendment 203. Minister to move formally.
Formally moved.
The question is that Amendment 278 be agreed. Are we all agreed? Yes. No. Okay. What's going on? I'm not agreed. I don't agree. We are not agreed. There will be a division. Those in favour of Amendment 278? Okay, everybody. And those against? The result of Amendment 278 is 6 for and 1 against. Therefore, the amendment is agreed. I call Amendment 81 in the name of Megan Gallagher, already debated with Amendment 207. I remind 203. I remind members that Amendments 81, 82, 83 and 84 are direct alternatives. That is, they can all be moved and decided on. The text of whichever is the last agreed to is what will appear in the bill. Megan Gallagher, to move or not move?
Not moved.
Not moved. I call Amendment 82 in the name of Megan Gallagher, already debated with Amendment 203. Megan Gallagher, to move or not move?
Not moved.
I call Amendment 83 in the name of Megan Gallagher, already debated with Amendment 203. Megan Gallagher, to move or not move?
Not moved.
I call Amendment 84 in the name of Megan Gallagher, already debated with Amendment 203. Megan Gallagher, to move or not move?
Not moved.
I call Amendment 480 in the name of Carol Mochan, already debated with Amendment 203. Carol Mochan, to move or not move?
Given what the Minister said, I won't move the motion, but I'll seek to bring it back, understanding what the barriers are.
Thank you. Thanks. All right, so now we're moving on to student tenancies and accommodation, right? Yes. Okay. So now we're going to move on to the next grouping, which is student tenancies and accommodation. I call Amendment 51 in the name of Graham Simpson, grouped with amendments as shown in the groupings. And I point out that if Amendment 281 in the group, rent control areas, amount of rent cap is agreed to, I cannot call Amendment 54 due to preemption. I also point out, as noted in the correction to the groupings, if Amendment 286 in the group rent control areas, amount of rent cap is agreed to, I cannot call Amendment 55 due to preemption. Graham Simpson, to move Amendment 51 and speak to all other amendments in the group.
Yeah, thanks again, convener. This is quite a hefty group, quite a lot of amendments. I've got a number. They deal exclusively with students. Now, I mentioned earlier the cross-party group on housing, where we produced another report, this time on student housing and homelessness. And that followed on from some very powerful presentations from students and a number of meetings that I've had with students and student organisations. Indeed, the Minister was at least one of the meetings of the cross-party group and heard for himself the presentations. So we produced that report. There were some challenging recommendations for government, and it's led to these amendments today, along with others which were actually considered by the Social Justice Committee. Now, you know, my strong view is if we're to have rent controls, that students ought to be covered by that system. And I'd love to hear from anyone who has a contrary view. If anyone has a contrary view, they can intervene on me at any point. The committee correctly identified in its excellent Stage 1 report that students have been overlooked by the bill in its current form. Well, we can rectify that quite easily. So let me turn to my amendments and others in this group. So Section 1 of the Housing Bill deals with the designation of rent control areas. Amendment 51 provides a definition for student residential tenancies, namely that this is a tenancy where the tenant has a right to occupy the let property while they are a student. And this amendment adds student residential tenancies to the definition of a relevant tenancy so that student tenancies might be considered within the rent control provisions contained in this bill. Amendments 52 to 58 just insert the word student into various sections of the bill. 52 says that the report which council sent to ministers recommending that an area be subject to rent controls should also include student tenancies. In Amendment 53, student tenancies must be included when a minister makes a decision about designating a rent control area. Amendment 54 again includes students in a subsection that makes reference to private residential tenancies, this time for regulations designated an area as a rent control area. 55 seeks to explicitly include student tenancies under the type of tenancy that's included within the definition of a rent control measure. And turning to 56. Yes, absolutely.
Thank you. I absolutely agree with the principles that Graham Simpson set out here, that students should benefit from the same protections as other tenants. I'm just interested in his thinking in terms of the approach to applying rent controls to the purpose-built student sector, i.e. that they should be covered by the geographical rent control zones that we're talking about, as opposed to other proposals that have been floated before, that we treat the PBSA sector as something entirely separate, perhaps a rent control zone in its own right. It's not a disagreement in principle. I'm just interested in the approach of grouping them into the geographical zones.
Mm-hmm. Yes, I've approached it because that is the approach in the bill. You know, so I'm working with the bill, I guess. And, you know, Mr Greer may not do that at various points. We'll come on to deal with his amendments later, but that's been my approach. I do think the PBSA sector needs to be looked at. My basic concern is that if we don't cover students, then, yeah. I mean, as I explained earlier, I'm against rent controls. My party's against rent controls, but we accept they're going to come in, so it ought to be a comprehensive system if we're going to have one, and it would be very unfair, I think, if students weren't covered. So turning to number 56, that adds student tenancies to the private residential tenancies that Scottish ministers may make regulations for under Section 14. 57 is another amendment to include student tenancies alongside private residential tenancies. Turning to 58, Section 18 of the Housing Bill relates to the power to modify the law in connection with the expiry of a rent control area. That section includes another reference to private residential tenancies, so my amendment seeks to include student tenancies. You'll see the theme. 59, Amendment 59 is a substantial amendment in that it gives ministers the power to subject student residential tenancies to rent controls. It doesn't say they have to do that, just that they can. And I note that Maggie Chapman is seeking to change may to must. I've got some sympathy with that, but I've had a brief chat with the Minister. It was brief. Now, we all know the Minister's a fan of consulting. I think, in fact, he could intervene on me if he wishes. I think he wants to consult on this one, but if he wants to intervene to clear that up.
In terms of the speaking notes, I'll pick on your points, Mr Simpson, in terms of that, which I'll touch on these issues.
That's fine. I'll get to close so I can address the Minister's comments. So I think, having spoken to the Minister, I'll wait to hear what the Minister has to say on this. Now, Amendment 60 adds student residential tenancies to the definition of a relevant tenancy. It repeals paragraph 5 of Schedule 1 of the Private Housing Tenancy Scotland Act 2016, which lists those tenancies which cannot be private residential tenancies, including if, quotes, the purpose of it is to confer on the tenant the right to occupy the let property while the tenant is a student. Repealing this part of the Act, the 2016 Act promotes greater equivalence between private residential tenancies and student residential tenancies. Amendment 75, this provides that the new regulation-making powers under Amendment 59, which empowers Scottish ministers to make provisions for student residential tenancies, be subject to rent controls on an equivalent basis to private residential tenancies, should be subject to the affirmative procedure. These amendments relate to rent control and rent increases, but not other aspects of the bill. Now, if I can just mention Maggie Chapman's Amendment 535, that deals with the issue of guarantors for non-UK domiciled students. Now, I've got a lot of sympathy with that one, not least because I'm also addressing this issue with an amendment of my own in a later group, but I'm keen to hear from Ms Chapman when she speaks to her amendments. I shall close there. Thank you, Convener.
Graham Simpson to move Amendment 51.
Moved.
Thank you. Maggie Chapman to speak to Amendment 59A and other amendments in the group.
Thank you, Convener. Purpose-built student accommodation can and does provide an important source of accommodation for students, but the sector, quite frankly, is getting out of control. A basic room in one PBSA block in Edinburgh's Vita block in Fountain Bridge is £406, not a month, but a week. £406 a week. That means a student will be paying over £1,600 for the smallest, just 20 square metres, and most basic room on offer. All this does is line the pockets of private developers at the expense of students, and at a time when, as we know, student homelessness is on the rise. NUS Scotland and student living rent groups across the country are very, very clear. Student accommodation must be included in this legislation. Students deserve the same protections as any other renters. That's why we need to look at controlling rents for student accommodation, and I welcome Graham Simpson's Amendment 59 to empower the Scottish Government to introduce rent controls for student accommodation. But the way Graham Simpson's amendment is written, as he's alluded to, the government does not have to do anything. And given the student housing crisis and the risk of homelessness that too many students face, doing nothing should not be an option for us today. So my amendments 59A and B require the Scottish Government to introduce controls into the sector. The detail of how we do this will have to come later, after, of course, the appropriate consultation, but I hope we can take this first step today. My other two amendments in this group, 535 and 536, address a different set of issues, highlighted to many of us, I'm sure, by NUS Scotland and by others. We know that international students, by virtue of not necessarily having family or other connections here in Scotland, can struggle to get a guarantor. However, we also know that international students are not likely, in fact, they are very unlikely to default on rents. So, 535 and 536 seek to introduce specific controls for non-UK domiciled students. 535 would create a guarantor scheme for non-UK domiciled students, whereby a public body would act as that guarantor for international students. This would mean that they wouldn't struggle to get rents simply because they don't have somebody who can say, yes, we will be that guarantor. 536 creates a review of deposits for international students, which can be a further barrier for students who not only don't have a guarantor, but don't have access to other funds in the UK. We know of too many stories where international students are asked to pay up front 3, 6 or 12 months rent in advance of signing a lease for a flat. That cannot be acceptable. We wouldn't expect any other renter to have that much money up front to pay for so much accommodation in advance. So I do hope we can move to reducing deposits so that the students we welcome here to study, and many of whom, of course, play such an important role in our communities, these students are not priced out of doing so. Accommodation is one of the key limiting factors for many international students, and I do hope that 535 and 536 will be taken seriously by members, because the situation is out of control. Thank you.
Thank you. And Edward Mountain to speak to Amendment 427 and other amendments in the group. And as Edward is not present, I believe Megan Gallagher is going to speak on his behalf.
Thank you very much, Convener. 427 sets out rent variations instigated by landlord's notice and the landlord's power to increase rent. 427, 428, 429, 430, 431, 432, 433, 434, 435, 436, 437, 438 and 439 all relate to a similar issue, where it brings student residential tenancies, purpose-built student accommodation, in line with private residential tenancies regarding landlords' power to increase rent and the protocol to be followed. And again, as I've just described, it's part of a wider group of amendment whose purpose is to include PBSA within the first-tier tribunals when dealing with the determination of rent. I do believe that my colleague Edward Mountain is seeking to bring these amendments back at stage 3. It would be helpful to hear from the Minister what he thinks in relation to these particular amendments in this section of the bill. If I may turn to Edward Mountain's Amendment 407. This, of course, is a different approach to what we've just heard from my colleague Maggie Chapman in relation to tenancy deposits of non-UK domiciled students. It is in my view that we are facing huge issues when it comes to student accommodation, but also housing students who are moving across Scotland or across the UK and being able to find that accommodation. And 407 sets out the amendment where landlords who do let to students overseas without a UK guarantor should be able to increase the deposit to 3 times the monthly rent. And again, this is to secure accommodation for students who are moving across the UK in order to find a university place, but also accommodation close by that university as well. I agree in terms of the amendments set out by my colleague Graham Stimpson in relation to students must be included within the bill. That was evident from the Stage 1 report outlined by this committee, that students have not been front and centre of the housing bill, but yet we're experiencing so many different issues with students trying to find a good accommodation, affordable rents, and we must look to improve the bill and seek to improve the bill in this particular area. But I'll finish my remarks there at the minute. Thank you.
Thank you. Jerry McBalfour to speak to Amendment 183 and other amendments in the group.
Thank you, Convener, and good morning, committee members. Gradually, I only have one amendment in regard to this whole bill, and as Megan Gallagher has pointed out previously, Convener, others of us are due at other committees as well, so I've asked my colleague if she will move or not move this amendment in due course, as I am due in another place already. We've already heard both from Mr Simpson and from Ms Chapman the issue around students and the need to give them more protection in regard to this bill. My amendment is similar but goes further than Ms Chapman in regard to the requirement for a guarantor. The reason that I brought this amendment forward is due to having a number of meetings with those, particularly within my own region at Edinburgh University. I think there are 2 issues which the Government and this Parliament needs to look at before this bill becomes an act. That is in regard to, as we've already heard from Maggie Chapman, in regard to overseas students. Overseas students arrive here looking for accommodation. Many of them know no one in the country, don't know how to get a guarantor, and are either having to pay excessive amounts of money in regard to that, or are unable to find appropriate accommodation. Now, what my amendment suggests, I'm not sure I'm going to press, but I would welcome the Minister's intervention on this when he closes to find out what way he believes can go forward. The second student I think we have to look at, and we are seeking to encourage people from different backgrounds to attend our universities here in Scotland, is those who come from a low-income background. For many of them, they don't have, again, that individual who can guarantee their rent. That is then putting them off in regard to perhaps the choice of university that they go to, or deciding what type of course that they do. This seems to me goes against everything that we are trying to achieve as a Parliament, and my understanding is that all parties want to see university open to anyone who has the academic ability rather than those who have the financial ability only. For that reason, I would welcome to hear what the Minister is going to say. I should say it is not my intention to move this amendment today, but I do think it is something collectively, perhaps with all these different amendments, we can come together on and look forward to something coming forward, either from the government or from myself or from another member at stage 3 to give that protection. Thank you, Convener.
Thank you. Pam Duncan-Glancy to speak to Amendment 537 and all other amendments in the group.
Thank you, Convener. Students, of course, as we've heard this morning, are a group which have been adversely affected and impacted by the current housing emergency. And in fact, figures from NUS Scotland show that 12% of students in Scotland have experienced homelessness while studying. We've just heard from my colleague Jeremy Balfour about how across this Parliament we want to make sure that people can study on the ability that they have, not on their ability to pay, and that is something that I think is incredibly important. For those who are in student accommodation, it's become increasingly unaffordable, insecure and poor quality, and students can't properly learn if they don't have warm, secure and affordable homes to live in, and so that is why I'm bringing forward my amendments on student tenancies and accommodation today. Amendment 537 on pre-tenancy requirements and student funding. I brought this because landlords can refuse to rent to some students, and some can express preferences based on the source of student income, such as loans or student grants. This can create challenges for students seeking housing, especially those relying on student loans or with limited income. So Amendment 537 in my name would require Scottish ministers to introduce regulation to provide equal status between student funding and other forms of income for the purposes of pre-tenancy checks. The purpose of the amendment is to ensure that students are not discriminated against depending on the source of their funding and are able to secure housing in the same way that those who are not students are able to do so. Amendment 541, Convener, am I okay to talk to the other amendments in my name? Amendment 541 in my name is the power to enable tenants to terminate student residential tenancies, and I know this is something that other members have an interest in too. Students are not currently defined as tenants if they live in private purpose-built student accommodation or halls of residence under the Private Housing Tenancy Scotland Act 2016. Purpose-built student accommodation is exempt from several tenancy regulations and instead falls under common law. So most notably, the 28-day notice period is something that students can struggle with in certain circumstances. Student accommodation continues to operate on a fixed-term lease, which is practical for the academic year. However, students who sometimes have very valid reasons to leave their leases often find it very difficult to do so, and the system gives providers a strong upper hand. For example, students who are on an interruption of study do not have the choice to end their leases in private PBSAs without incurring costs or being required to find a replacement student. The same is the case for students who withdraw from their studies. Amendment 541 will give Scottish ministers, where necessary, the power to provide for a student residential tenancy to be terminated by a tenant in the same manner as a private residential tenancy may be terminated by a tenant under Part 5 of the 2016 Act. The purpose of the amendment is to ensure students in PBSAs can end their contract with the student accommodation provider if they withdraw or are on an interruption of study and will not incur any financial losses or emotional distress as a result of their decision. Amendment 474 on purpose-built student accommodation charter. Purpose-built student accommodation typically costs 30 to 50% more than the average rent in any given area. And in fact, rent in PBSAs have increased over 34% between 2018 and 2021, which is much higher than the rate of inflation. This means that PBSA is often financially inaccessible to students from low-income backgrounds, and particularly from SIMD 20 areas in Scotland. As a result, some students are left with no choice but to travel long distances from their family homes, face homelessness or unsuitable housing situations. Furthermore, increased prices for PBSAs don't reflect a higher standard of accommodation always, and the NUS report pointed out that the quality of student accommodation can affect students' mental health and well-being and in turn their ability to study. Amendment 474, therefore, would require Scottish ministers to publish a purpose-built student accommodation charter within 12 months of the Act coming into force. And I'm aware that the Scottish Government are working with universities and University Scotland to look at practice and codes in this particular area. But I'd be keen to see what can be done in legislation to give a statutory right and responsibility for such a charter. This would set out the purpose of purpose-built student accommodation, the rights and responsibilities of landlords and tenants under a student residential tenancy, and the process for dispute resolution. It could also include standards and outcomes which landlords would aim to achieve. And the purpose of the amendment is basically to ensure that landlords and tenants are aware of the purpose, and I think it's for government to set this out via regulation, but the premise of it is to ensure PBSA is affordable, accessible, safe and connected. Amendment 475 in this group in my name is about bringing forward a purpose-built student accommodation strategy. As a percentage of accommodation across Glasgow alone, student accommodation makes up 28% of approvals since 2015. This is in spite of the fact that students make up only 18.5% of the population in the city. Students and residents across all areas in Scotland and all cities and regions in Scotland need accommodation, but they don't all want to have purpose-built student accommodation, and residents need to have a wide range of affordable housing options to them too. So Amendment 475 in my name would require the ministers to prepare a purpose-built student accommodation strategy that would set out ministers' objectives with regards to purpose-built student accommodation, their plans for meeting those objectives and arrangements for monitoring progress towards them. It could include aims for the ratio of student residential tenancies to other types of tenancies and the government's view on the role that PBSAs would have within the available housing stock. In preparing the strategy, my amendment sets out that ministers would be required to consult higher education institutions, local authorities, representatives of students, but crucially too, non-students and residents in local areas. Ministers would be required to lay the Charter before the Scottish Parliament and the strategy, and the purpose of the amendment would ensure a more strategic approach is taken to the provision of different housing tenures in any local authority area. And Amendment 556 is a consequential amendment to Amendment 537. Thank you, Convener.
Thank you. Ross Greer, to speak to Amendment 540 and other amendments in the group.
Thank you, Convener, and good morning, everyone. My amendments in this group cover a lot of the same ground as Pam Duncan-Glancy's and Graham Simpson's in particular, and I think it is an example of just how strong the consensus is about the need to improve the living conditions of students, that we're spanning the whole ideological spectrum here, from myself and Maggie Chapman to Graham Simpson, Edward Mountain, in reaching a consensus around this point. My Amendment 540 gives tenants in student residential tenancies the right to bring their tenancy to an end after 20 days' notice. And it's a copy and paste of the temporary provisions from the Coronavirus 2 Act of 2020, thus the anomalous-looking 7-day provision for existing tenancies. Given the volume of work for the legislation team on this bill, I thought it was quickest to copy-paste the 2020 drafting at this stage to test the principle of bringing student tenants' rights closer to that of other tenants. If the principle is agreeable, of course, I would be tidying that up at stage 3 to remove the now superfluous 7-day provision. Bringing this in would avoid tenants in student halls being essentially trapped in their tenancies, like Pam Duncan-Glancy said, when they no longer need it. For example, if they need to leave their studies due to illness or change of family circumstances, sudden caring responsibilities. It is very rarely motivated by or caused by a positive change in circumstances that a student would have to leave their accommodation. So these are people who are already experiencing some kind of difficulty. And it's an issue that the Scottish Government has consulted on already. The consultation took place in July of last year. And as far as I'm aware, the Government haven't published their response to that yet, certainly not anywhere that I could locate. If this principle is agreeable. I would also be looking to work with the government head of stage 3 to capture some of the other issues that were explored through that consultation. So the issues of fines or fees for the early ending of the tenancy, for example. I think there is a legitimate concern that can be addressed about the impact on the PBSA business model and providing some compensation to them without a student who, for example, leaves before Christmas, having to pay for the full year, I think is entirely achievable. Now, my Amendment 548 mandates ministers to publish a model set of terms and conditions for student residential tenancies, covering the topics listed in the amendment as a minimum, but not as an exhaustive list, with the power to make some of those provisions mandatory for relevant tenancies. So this mirrors the existing model tenancy agreement for the private rented sector, so continuing that theme of equalising students' experience of housing with that of other private renters. So this would guarantee a minimum standard for student residential tenancies, and it delivers on one of the recommendations of the government's own PBSA review group. The amendment would tackle a number of the commonly raised issues that came up during that review, for example, cooling off periods, data sharing, information, support, etc. And it brings student tenancies closer into line with private tenancies in terms of their rights. For example, a 24-hour notice period for maintenance and inspection, something that I think we would all consider to be completely legitimate, as well as issues like notice of rent increases and a cap on deposit amounts. Noting the other amendments to apply rent control provisions to student tenancies in particular, my Amendment 548 would allow the Scottish Government to set a mandatory condition on rent affordability, particularly in relation to or relative to available student support. So, for example, that the rent in a PBSA could be no more than 30% of the basic SAS living costs loan, for example. The sector have always claimed that their terms and conditions are already adequate, but the PBSA review and our inboxes show that really the reality is quite far from that. I think it's important that we have some statutory provisions here, and this is the only legislative vehicle for us to do that in this Parliament. Non-statutory model terms and conditions would go on to gov.scot and immediately be forgotten. And I brought these amendments forward because we're 15 months after the PBSA review recommendations were published, and I'm really not seeing evidence of progress, and particularly in relation to anything that would require statutory provision. As I said, this is really the last vehicle for us to do that. Amendment 549 mandates ministers to publish a model complaints procedure for student residential tenancies, which may be made binding. It clarifies and standardises tenants' right to complain, and it makes and to make other representations to their landlord. And again, this is delivering on one of the recommendations of the PBSA review group. Amendment 559 and 560 are consequentials, 559 to 548 and 560 to 549. That any regulations made under those amendments are subject to the affirmative procedure. Thank you, Convener.
Thank you. Would any other members wish to speak? No? Minister.
Thank you, Convener. I think that's been a really interesting debate in terms of some of the consensus, and I'll touch on suggested ways ahead in the speaking notes. I'll speak in individual amendments just now, and then touch on the points that I mentioned. There are amendments 51 to 59 and 75 in the name of Graham Simpson. Amendments 59A and 59B in the name of Maggie Chapman have the effect of including student tenancies within rent control. Amendments 427 to 439 and 441 in the name of Edward Mountain support the inclusion of student tenancies in rent control through creating a new process for increasing rents within student tenancies. These measures also would have an impact on the PBSA and university halls of residence. Now, while I understand the members' concerns in relation to affordability of accommodation students, there are calls to include student tenancies in rent controls that could be applied in relation to rent control areas. There are significant concerns with the approach due to lack of alignment with how the student accommodation sector operates in practice. I would therefore not support these amendments proposed by Graham Simpson, Maggie Chapman and Edward Mountain, but I'll touch on the suggested way ahead later on in terms of that. Student accommodation provision operates on a different basis from the wider private rented sector, taking account of the need of students. As a rule, students seek accommodation for a fixed time period covering the academic year at a fixed cost. This is unlike the wider PRS, where tenancies are open-ended and must be brought to an end by the tenant or landlord. This is reflected in the business model of PBSA and university accommodation providers, which align move-in and move-out dates with the academic year. PBSA will not generally be rented to those who are not students during term time, and university halls of residence are generally rented only to students of the institution in question during term time. As such, student accommodation cannot be considered as part of the wider supply of rented housing available to all tenants. In addition, rental costs for PBSA and university halls usually include more than just rent. As a result, student accommodation costs are not generally directly comparable to mainstream rents. The inclusion of student tenancies within rent control would be a significant change. Yes.
Thank the Minister for taking the intervention. I know he's going to come on to outline a way forward, but just so that I can understand what he's saying, just so I understand his argument, is his argument that because student halls of residence may at some point during the year be rented out to or let out to other people other than students, they shouldn't be subject to these rules?
No, I think it's obviously it's something that does happen at the moment. I think it's an issue that needs wider discussion, and I'll touch on where the role. And I think Ross Greer also mentioned the point about the PBSA review group, and I think it's important for us all to engage with the PBSA review group on these particular matters, not just in the matter that you raised there, but on other wider issues. So I'll come on to suggested way forward in terms of how we engage with the PBSA review, because I think it's important, because that group obviously has providers, has universities, has local authorities, has student groups in terms of that. So I think in terms of what's all being proposed here, I think it would be really important to engage with the PBSA review group in terms of what the work they've done and what their thoughts are on some of the amendments, which includes all the major stakeholders in that. But I'll come on that specific point in terms of that. So as I said, the inclusion of student tenancies within rent control would be a significant change to the measures set out in the bill, and there has been no prior consultation with student tenants or accommodation providers on this. There is therefore no clear understanding of the potential implications these measures could have in the provision of student accommodation for providers or for students. Amendments 51 to 59 and 75 in Graham-Simpson would have the effect of including student tenancies within rent control and giving Scottish ministers the power to set out in regulations the necessary provisions to allow for this. Amendments 59A and 59B in the name of Maggie Chapman have the effect of requiring Scottish ministers to exercise these regulation-making powers to set out such provisions. Amendment 60 in the name of Graham-Simpson would amend Schedule 1 of the 2016 Act, tenancies which cannot be PRTs, to remove paragraph 5, student lets. This would have the effect of making every student tenancy in halls of residence and PBSA a private residential tenancy. That would mean every student tenancy would be regulated in the same way as a private residential tenancy. There would be no fixed duration, so the tenancy could only be terminated on notice being given by the tenant or an eviction by the landlord. I am therefore asked the member not to press this amendment. Amendments 427 and 429 and 441 in the name of Ferdinand Mountain seek to replicate the regulation of rent increases in private residential tenancies for student tenancies and raise similar concerns. As I have said, rent increases in student tenancies do not generally take place during the tenancy, as therefore a fixed duration, and this amendment could make way for a change in that approach which could be unwelcome. I am therefore not convinced of the need for these provisions. In addition, there has been no consultation with the sector to understand the impact or suitability of the approach set out. Given the unique nature of the PBSA sector, we don't think it's appropriate to extend certain measures in the bill to cover those living in PBSA. The recent review of the PBSA looked at a number of issues, including supply, affordability and regulation. Work is ongoing to forward recommendations coming out of the review. It's important this work is allowed to conclude before any decisions are making, and I'll touch on that point in a little second. Yeah.
I'm grateful to the Minister, and I recognise and I appreciate the importance he's placing on the PBSA review group, but their recommendations were published 15 months ago. A number of their recommendations would require a change in legislation, and yet the Government has not brought forward any amendments to deliver that change in legislation through this bill. Can the Minister just confirm that unless we do it through this bill, there will be no legislative vehicle in the remainder of this Parliament?
I think, and recognise the points that have been made, and I'm also recognising the consensus that's kind of come out of the debate today. I think it's important in terms of we're discussing at stage 2. And I think one of the key things for me is a consultation with the PBSA review group, which includes the major stakeholders in that particular point. The PBSA review group will have to conclude its recommendations in terms of that. I'm aware that there's no other measures that would come forward in legislation out of that particular review group in that particular time. But I think it's important before we progress with stage 2, some of the amendments have been forward that we engage with that particular group, and I'll touch on that in a little second, Mr Greer, in terms of how we take that forward, in terms of all the amendments have come forward, but engaging with the group, which I think the PBSA review group, which includes major stakeholders, which I think is important. And obviously consideration on that particular point is whether members then decide to push on stage 2 and stage 3, and where the government takes that. Yeah.
the Minister for taking intervention. I think Ross Greer raises a really important point. It's been 15 months since those findings have been brought forward, and also the Housing Scotland Bill Stage 1 report was published on the 14th of November 2024. Again, both of these issues heavily feature concerns from students, student bodies, student representatives on these particular issues. So I think what we're basically trying to say collectively is progress has been very, very slow, and I'm also concerned that there might not be opportunities now, if these amendments are not looked at least, where we can actually have legislation that will help protect students moving forward. So I think the Minister does need to take this seriously, and I hope that he will conclude that he will work with members to look at some of these issues to tease it out before stage 3.
Yeah, just coming back to the point that was mentioned by Mr Greer, yeah, I think one of the key things, and I'll probably come at the point, I think it would be useful, either individually or collectively, for us all that have raised amendments here to engage with the PBSA review group in terms of the amendments that are there, to discuss that with them, and obviously that would be with myself as well, but with the PBSA group. So that includes all the major stakeholders, I think, who are incredibly important in dealing with this. So, I mean, I said that I was going to come on to this, but I think in terms of that, I'm happy to meet either individually or collectively. Now, to have to obviously contact the PBSA review group, I am sure they would have no issues in trying to engage with members on the amendments that have come forward in terms of this. So it's recognising the points that have come forward from the committee today, the amendments that have come forward. For me, I think it's incredibly important we engage with the sector in terms of what their thoughts are and ways ahead in terms of this. Obviously, at that stage, it's up to where government would continue to push this, and obviously individual amendments are pushed at that particular point. But I think it's incredibly important that we engage with the sector to discuss these on a much broader basis. But happy to take that, as I said, forward individually or collectively on that particular point. Yes.
I thank the Minister for taking an intervention. Can I just check then, for my own understanding, is the Minister suggesting that there's engagement with the review group with a view to the government bringing forward some amendments at stage 3?
No, I can't come forward at this stage and say what would the government would do at that position. That would have to be discussed obviously with colleagues in terms of this. But what I am saying is obviously I think it would be really important for me as a Minister and engaging obviously with, because I've heard the consensus that's coming out today, I think engage with colleagues and other parties about the amendments now. That might be something we can come to agreement or not, and that's obviously a process for stage 3. But I think it's really important, I think, in terms of what we've heard today, there's a consensus coming through quite clearly in terms of some of the issues. What are the thoughts of the PBSA review in terms of that? What's their views in terms of how we take that forward? Now, they'll probably come forward with a response to say that includes all the major stakeholders. I think then it's up for all of us to go away and reflect on what comes through that engagement. And obviously that would be before stage 3 on that particular point and come back. Yes.
Has he not asked that question already?
We've engaged with the PBSA group in
what did they
terms of this. Well, again, on different amendments that some of these amendments, as you can appreciate, came in at a late stage, Mr Rennie. So again, some of these were quite new in terms of that. The amendments have just been lodged. So we've been engaging with the group on a regular basis, but some of these amendments have been lodged for a short period of time. As you appreciate, there's been a large number of amendments on this part of the bill as there was in the previous part of the bill. So I think it's important that we engage with the PBSA review group itself in terms of the amendments that have been brought forward. I know there's a Timmy's point to that, and we need to engage with them as quickly as possible.
Would the Minister take further intervention?
Yes.
Very grateful. I think what members are looking for from the government is an indication of where the government agrees with the principle behind these amendments. If there is agreement on the principle of them, the government recognises the consensus across the Parliament. If the government can agree with that principle, and it's simply a question of working with the PBSA review groups to find agreeable drafting for stage 3, that would be one thing. But if the government actually disagrees with the principle behind these amendments, if the government disagrees with the principle that student tenants should have the same right to end their tenancy as private students, if the government disagrees with the principle of a model set of terms and conditions, as the PBSA review group has already recommended, and I believe the government's already accepted that recommendation, if the government disagrees with those principles, then there's not really any incentive for members to hold back at this stage and come back at stage 3. I think what we're all looking for is an indication from the government on the point of principle behind each of these amendments. If that's there, then there is the scope to work with the government for stage 3. If there's not, my intention would certainly be to move my amendments at this stage and see what the view of the committee is.
I think in terms of all these, I think one of the important things is engagement with the PBSA sector itself. Now, as I appreciate, I think one of the key things right the way through the bill, was in terms of consultation, and I think it mentioned about the consultation not having the PBS review group obviously has been engaging in this in terms of the consultation on the specific individual amendments. I think that's something that I would like to engage further with the PBSA sector on and work together with members on that particular point. Now, I think it's important that we take the views of the sector itself. Now, it's up to us as individual members or as government about what response kind of goes forward in that. So, again, I think that's something we can do on a very early basis just now. So I'm asking members not to push it at this stage, but given that offer of meeting with the PBSA group and obviously having the ability to bring that forward at stage 3. So, yes, of course.
Just for a point of clarity, my understanding is that when the PBSA review group published its set of recommendations 15 months ago, that the government accepted those recommendations. The Minister so far hasn't confirmed that. Could he confirm if the Scottish Government has accepted the recommendations from the PBSA review group as set out 15 months ago, or if that is no longer the Scottish Government's position?
I think in terms of where it was 15 months ago, the Government accepted the recommendations. I've been working with the sector in terms of how that would be implemented. And I think that's an important point for myself, is in terms of that, it's about how that would be implemented. And that's the point I'm trying to make in terms of further consultation that would be required. So that was accepted. However, I think the important, because it was an independent review group, I think the important part of that is how these would be implemented. So in terms of the principle, in terms of how it's implemented, I think that's where they would merit further discussion in terms of that. So, and I think that's an important point, is how would these be implemented. The amendments that have come forward at a relatively late stage in terms of after the PBSA review group, I think need further discussions with the group itself in terms of how these are implemented. So that's what I'm kind of saying at this stage, not to press the amendments, but continue to work with myself and the sector in terms of that. Happy to have individual discussions about the individual amendments that have come forward at that stage as well. But I think collectively, it would be advantageous for us all to meet with the PBSA review to discuss that as we look forward to the amendments. Now, it's up to members whether they want to push at this stage or not. What I'm asking at this stage is, I think it's important we have discussions about the implementation of these recommendations in terms of the amendments to discuss further with the review group at that particular point. So I'm asking members not to press at this stage, but as I said, willing to engage with members either individually or collectively with the PBSA group regarding the actual implementation of these. So I don't know if there's any further amendments. Amendment 183 in the name of Jeremy Balfour. In response to concerns about difficulties that students in purpose-built student accommodation have in providing a suitable guarantor. Whilst well intentioned, it could inadvertently make things more difficult for students, particularly for foreign students and those from poorer backgrounds, to find accommodation, increasing their risk of homelessness. This is because a guarantor and advance rent are both options that can be used to facilitate a let where the prospective tenant is unable to demonstrate sufficient income or creditworthiness. I would ask the member not to press this amendment. And Amendment 407 in the name of Redburn Mountain will increase the maximum limit for tenancy deposits from 2 months to 3 months for international students where they are not required to provide a guarantor. I understand that there can be barriers for international students to access the PRS sector, and as such has a difficulty being able to provide UK-based guarantors. However, the introduction of an increased deposit amount in place of guarantor requirement is unlikely to be sufficient reassurance for private landlords where a prospective tenant is unable to sufficiently demonstrate income or creditworthiness without a suitable guarantor. Careful consideration would also need to be given to ensure a fairer approach for all students, and this amendment does not strike that balance. I therefore ask the member not to press the amendment. Turning to Maggie Chapman's Amendment 535, which would require ministers to establish, through regulations, a public body to act as a guarantor for non-UK domiciled students. I'm sympathetic to the outcomes that she is seeking to achieve. However, this would be a complex issue with ongoing financial implications for the Scottish administration. There are a number of rent guarantees schemes across Scotland operated by universities, local authorities and charities which can help tenants who are unable to make use of other alternatives to access rented accommodation. A quicker and more effective cost alternative would be consider these avenues would be strengthened. I'd ask the member not to press the amendment at this stage. Yes.
On that, so the Minister's mentioned that there are other rent guarantor schemes across Scotland, but quite often international students are not allowed to access those. And he says, you know, can we make these existing avenues stronger and possibly include? Has the Minister had any conversations with any of the existing schemes to explore what might be possible, given what he said in response to both my amendment and Jeremy Balfour's amendment?
It's been an issue that's been raised in the PBSA review group and in discussions within, and that's an issue that they're trying to take forward in that particular regard. So again, coming back to the discussions with the PBSA review group, I think this is an issue that could be explored again, that opens the alternative for Maggie Chapman to press the amendment at stage 2 or at stage 3 after these discussions have been held. But it's an issue that's been discussed within the PBSA review group itself.
And is the Scottish Government sympathetic to finding some solution for students,
yes,
regardless of whether they're international or students or not, but who struggle to get guarantors?
Yes, I think it said that in the speaking notes. We're sympathetic to the outcomes. I think it's in terms of engaging with the sector, in terms of what's already there, about strengthening it, if not, and then we look at it in terms of what we're doing. Again, it comes back to the point mentioned about engaging with the PBSA review group on its own. But yes, I mentioned I was sympathetic to the intentions that you've stated in your amendment.
Okay.
In terms of that. So, Amendment 537556 under the name of Pam Duncan Glancy to provide ministers with enabling power to make affirmative regulations to set out requirements so student funding has equal status to other forms of income. Well, well-intentioned, I'll just finish this point. I don't think additional regulations in that area would work in practice.
Sorry, Minister, I wanted to ask a question about 536. I thought you might say a little bit more about Amendment 536. Which is about deposits.
Yeah, I'll come on to that in a little second.
Okay,
yeah.
Apologies.
So I'll come on to that point just on 537. I'll come back to 536. It is also unclear how such commandments could be effectively enforced with no formal agreement being in place between the prospective tenant and the landlord or agent. Setting additional requirements in this area may also inadvertently discourage mainstream landlords from letting to students other than supporting better access. I therefore ask the member not to press on this particular point. Yes.
I'm not sure I understand the Minister's logic. Could the Minister set out why he thinks it would be difficult to bring regulation in that area and what he thinks the problem would be for landlords to determine this source of income is equal to another source of income?
I think I mentioned there, I think there's been no formal agreement being in place. I think between the tenant and landlord or agents, I think that might discourage that. I think there's a number of things, and I'll touch on that. It talks, I was going to come on to that in terms of income. I think it's just one of the requirements in terms of this. So I'm happy to engage further on that particular point with Ms Duncan Glancy on that.
Will the Minister take an intervention?
Yeah, of course.
Does the Minister recognise that student loans are used for income in other areas?
Yes, I think, yeah.
And so they're recognised as income for other areas. And so can I ask why not this one?
Bear with me just a wee second. I think in terms of that particular point, I'm happy to engage on that point. Again, this has been an issue that's been raised within the PBSA review on that particular point, and it's trying to recognise individual circumstances within that, but I'm happy to engage with you on that particular point going forward.
Okay.
So I want to come back just to the Amendment 536, and that's also in the name of Maggie Chapman, to gather more information about non-UK students and tenancy deposits. This would then support the use of regulatory powers provided this by an amendment. However, there are practical issues with obtaining the data sought. The tenancy deposit schemes do not currently collect any information from tenants, which would enable them to establish whether the tenancy deposit protect is for a non-UK domiciled student, and placing a requirement on the schemes would be a significant change with resource and cost implications. I have concerns about the proposed enabling regulations. Placing restrictions on the amount of tenancy deposits can be placed by a non-UK student may also result in unintended consequences of landlords choosing not to let their properties whilst they can't obtain sufficient security over the property. I have concerns about treating non-UK students differently, and the need to ensure a fairer approach for all students. I therefore ask the member not to press this amendment. Yeah.
Questions on this. The Minister says that he doesn't want to, he has concerns about treating international students differently with a system that would restrict upfront rent payments. But they're already treated differently. International students are already treated differently by the sector. It's international students who are often asked for 3, 6 or 12 months rent upfront. UK domiciled students are not asked for that level of upfront costs. So the sector is already treating international students differently, and they are therefore disadvantaged as a consequence of that. So this is actually, this scheme would be an attempt to equalise the system so that they would not be treated differently. And I just wondered what the Minister's response to that point is.
Yeah, and obviously recognise that. And I think, again, this is part of the issue that's been discussed with PBSA review in terms of what they're looking to do on that particular point. And again, it comes back to the point of engaging. So I think obviously sympathetic to the intentions of Maggie Chapman at this stage. I think in terms of what we need to do is engage with the sector around about the work that's already ongoing. within the sector on that particular point. And again, this comes back, I think, to the importance of the engagement with the sector and the ongoing work that's going on within the PBSA review group, in terms of that. So I think it's important at this stage to recognise the work that they're already doing and already looking at this stage.
My final question on this, is it the Minister's view that the sector, PBSAs, should not be able to treat international students differently?
I think one of the important things is obviously ensuring that we get make the overseas students have an ability to come into Scotland.
So should they be treated differently or not?
No, I mean, I think obviously we need to encourage them in terms of, I mean, landlords, for example, would have, and we know there's been issues. I think we've all had casework. There's been issues with foreign students coming over. I think in terms of that particular point, but it should be made as easy as possible for them to come across and reside in Scotland. Now, obviously, that's recognising where the landlords sit in that particular point as well. So again, that's something that I'm sympathetic to the point in being looked at. We should be working with the sector in terms of how we engage with them to progress that and make it as easy as possible going forward. And I think that's part of the work. I think that's part of the engagement with the sector who are looking at this. I think in terms of that particular point.
Thank you.
Amendment 540 in the name of Ross Greer would enable students living in the PBSA to bring their contract to an end either 7 or 28 days notice depending on when the congregation agreement started. A 28-day notice period would reflect notice period in the mainstream PRS. The amendment reflects the temporary emergency legislation in response to COVID. While I understand the amendment, I can't support it. The Scottish Government led a review, as I said, of the PBSA review group working with a multi-agency group, the outcome of which was 11 recommendations. Now, this has covered issues such as regulation, supply and affordability within the PBSA sector. Now, these are currently being progressed and comes back to the point I made to Mr Greer about undergoing with the sector on that particular point. There have been further consultation on notice periods which have been undertaken by the way of student and provider surveys with the results currently being analysed. In addition, PBSA is a very different type of agreement. Voids in PBSA can be filled by students, which is difficult mid-academic year. Can only be filled by students, which is difficult mid-academic year. This amendment would have substantial impact on the current operation of PBSA, with the possibility of higher rental costs for students and an increase in affordability issues. Yes.
I'm grateful to the Minister. He's making two lines of argument against my amendment. One that we've heard already this morning about the need for further consultation with the PBSA review group, and the second is an argument in practice against the principle of students being able to end their tenancies early like any other private tenant. Could I just clarify, is the Scottish Government's position that students in PBSAs should not have the same right as other private tenants to end their tenancy early because of the different business model? Because again, like we said before, if this is an argument about the need for further consultation with the review group to bring amendments to the same effect at stage 3, that's one thing. But it sounds like the government disagrees with the principle that PBSA tenants should have this same right to end the tenancy early. So I'd be grateful if you could clarify that.
No, again, it comes back to the consultation. I said there was in terms of the consultation in respect to the notice period. I said obviously there was student and provider surveys. The results are currently being analysed now. Until the series, obviously the government would come to a position on that. I think it's important again the consultation within the PBSA sector is important in terms of that. So again, that would be something in terms of what the survey would come through and that the result of that, what the government position would be going forward.
Would the Minister take?
Yeah.
Can I just clarify then, because I don't know if committee members are aware, but I'm certainly not, with the timescale of processing these consultation responses. Is the Minister indicating that the Government's intention would be to collate those consultation responses and come to a view ahead of stage 3 and therefore be able to bring any amendments forward at that stage? Because if amendments are not brought forward at stage 3 of this bill, as I said before, there is no other legislative vehicle to make these changes in this Parliament.
And I think that's a point that's been mentioned. So again, I think in terms of what the results would be, I think it would be obviously up to the government depending on the results of the analysis in terms of what it would do. Now, taking into cognizance the point you mentioned and about the only way to do that would be through the stage 3 of the bill.
For taking intervention. Thank you, Minister. My question was similar about timescales, because I think what I'm hearing in relation to a number of the amendments is the need for consultation with the review group. But I have to say I share Ross Greer's concern, if I can use. I don't want to put words into his mouth, my colleague's mouth, but I share the concern that we're not really hearing about let's consult that group to bring forward amendments doing the same thing but with some specific amendments in them for stage 3. So again, can I ask the Minister, is the Government prepared to bring an amendment at stage 3 looking to address the issue that we're discussing just now around student loan income?
I think again it comes back to the point that I mentioned before around about whether it's whatever the amendment this is on. I think it's important that we speak to the sector in terms of that. Now, the government would then, if it agrees with the points that have been mentioned, would look at in terms of that. I think it's incredibly important for me that we engage with the sector before we make any final decisions on what's brought forward at stage 3. I've indicated some sympathy with some of the amendments that are there, but I think some others would need to be, for example, analysis on the notice periods. I think it's important that that analysis is considered and considered at that time before we bring something through at that particular stage.
Will the Minister take a further intervention?
Yeah.
Does the Minister recognise that members will have done some of that engagement?
Yeah, of course I do. I mean, I know members have done that over a period of time. I think the collective PBSA group is where it's important to get that broader. There'll be a number of interests in the sector, whether it's through providers, whether it's through investors, whether it's through student groups, whether that's through universities, whether that's through local authorities. I think it's important to get that widespread consultation in terms of the amendments that have been brought forward. As I said, many of which have been brought forward, obviously, at a later stage as part of the process and not allowed that extensive consultation, which again, now I think part of that I think is something that has been brought forward in the PBSA review recommendations. But however, some of the recommendations which come forward at a later stage have not had that broader engagement with the stakeholder group, which I would encourage members to do. I'm happy to arrange that with the group and speak to the group and discuss individual recommendations also at that stage. So, as I said, I thank Pam Duncan-Glancy for bringing forward amendments 474 and 475. At this stage, obviously, I think I think it's important that we have that wider discussion with the PBSA review in terms of that. With regards to Amendment 474, the review made a specific recommendation on development of a model terms and conditions for the PBSA sector to support improvements in the consistency of the rights PBSA tenants could expect across all providers. To implement this recommendation, work is underway with the sector to develop model tenancy agreements, alongside work to develop a model complaints procedure to ensure all PBSA tenants are empowered to raise future complaints. Apply for one in a second. I think just to cover, I think in terms of Amendment 541, in the name of Pam Duncan-Glancy, it raised some considerations with that. Whilst I recognise that the measure provides enabling power rather than requirement, it's premature that the need for action in this area has not been recognised. With regards to Amendment 475, I understand the drive to recognise issues around about the supply of affordable student accommodation and clarify plan and future actions in respect of changes to regulation of student residential tenancies. These were key issues which were recognised in the PBSA review work and were reflected in the review group's final recommendations. In particular, recommendations were made around the importance of effective partnership working at local level, which again is important. That's where local authorities have been involved in terms of that broader work, involving those involved in provision and use of student accommodation to consider supply issues at local level in the short, medium and long term. The PBSA Review Implementation Group has undertaken work on this collectively to drive action and to progress development of local strategic partnerships. Yes.
I thank the Minister for taking the intervention. Does the Minister and the Government recognise, though, that the work that he's outlined is still resulting in a less than strategic approach to the ratio of residential, affordable and cross-tenure and purpose-built student accommodation within each area, and that perhaps a strategy could bring some coherence to that?
Having been involved in the PBSA review group, that's one of the key areas that the group is actually looking at the moment, is that particular point where you've had both Edinburgh and Glasgow and local authorities and how does that then feed into the wider housing, I suppose, supply and housing strategy at that particular time. So that's a key piece of work that local authorities are doing on that particular point in terms of that. So the work is ongoing, hence coming back to the work, engaging with the PBSA review group in terms of that. So I think the points that you raise are important. I think it needs further discussion with the implementation group that's already ongoing at this stage about how that could be in terms of your own amendment, what the best way would be to proceed in that. So it's coming back to the principle for me, as I said, there is already work that the PBS review group is doing in terms of implementation. In terms of the amendments that have been brought forward, I think it's important that we engage with the group to where we all can go with this and conclude in this in terms of what would you do at stage 3. So that work is already ongoing. I think it's important that we engage more collectively and I suppose more widely in terms of some of the work that they're already doing.
And on a point of clarity, if that's okay?
Yes, of course.
Can I just check then, is the Minister in principle supportive of a charter and a strategy on purpose-built student accommodation?
Again, I think that's something that the group are discussing at this particular stage. So for me, it's important that we get the conclusion of that review group and in terms of what they're saying. Now, I think I've obviously been reflective in terms of what's been said today in terms of where members are with stage 2. The point I'm trying to make all the way through this is in terms of the PBSA review and implementation group is already doing some of this work. It's important, I think, before agreeing to these amendments at stage 2 that we have consultation before anything is brought forward at stage 3. That would allow, if I can just finish, that would allow me to conclude in terms of where we are with the amendments and also more broadly in terms of where the group is with the amendments also.
I'm grateful that the Minister's mentioned a number of times this morning about amendments coming in relatively late in the process. I just want to clarify the timeline here. So the PBSA Review Group reported in February 2024. The bill was published in March 2024, so I accept that this couldn't have been written into the bill. It had already been signed off at the point the Review Group published. But there's been 15 months since then. I can't speak for other members, but my intentions to amend in this area were sent to the Government in January of this year. Could the Minister confirm, have discussions already taken place with the PBSA Review Group in relation to recommendations they made that would require statutory change and therefore what amendments would be required for this bill? And if those discussions have taken place, specific discussions with the Review Group about what could be changed via this bill, could he just clarify to us which specific elements of their recommendations
not on
that
the
was?
specific recommendations, not on the specific amendments on the bill. The group has met more generally to discuss some of the recommendations that have been taken forward and still continue to meet on that particular point. It's not discussed as far as I'm led to believe. I mean, I've attended a number of meetings, there have been similar ones which have just been stakeholders themselves. Not as far as I'm aware, there have been discussions about the individual amendments that have been brought forward.
Could I ask the Minister why not, given that the key argument that he's giving against these amendments at this stage is a lack of consultation and discussion, given that we've had 15 months since the Review Group's recommendation, at least in case of my amendments, as I said, I can't speak for other members, the Government's had 4 months. Why has no discussion taken place?
Well, as I said, the group have met to discuss their own recommendations at this particular point, not knowing which recommendations would be brought forward at that point. They've not discussed individual recommendations. Yes.
I'm going to close in this group, so I'll have more to say then. This has been immensely frustrating, and I feel the pain of Mr Greer and Miss Duncan-Glancy. Some of these amendments, many of these amendments, have been in for some time now. I lodged my amendments ages ago, as soon as I could. The Minister has seen them. If he's hiding behind this review group, they should have seen them, not just mine, others. They and the Minister have had time to consider these amendments. Why is that not being done by the review group? That's a question.
Yeah, on that particular point, I said the review group itself has been discussing the implementation review and not the bill on its own particular regard. So just to continue, convener, on that particular point, I mentioned around about the amendments in terms of conditions. Complaint procedures are also provided. Yes.
Did he ask the review group to consider the amendments? Did he not think that would be an appropriate thing to do?
I think in terms of that, officials have been discussing that with the review group. I've not met the review group for a period of months in terms of this in preparation for the bill.
Sorry, would the Minister take an intervention on that?
Yes.
I think this is actually quite a frustrating point, because I think Mr Greer actually lays out something that I think makes an awful lot of sense. That if the government's position is that it can't take a position because it's not had time to consider these amendments, but these amendments both in substance, but actually also more importantly, and Mr Greer's point here is really important, in principle, have actually been discussed for some time because this bill has been in the public domain for that period of time. And if it's also the government's position that it can't come to a position because it hasn't consulted with the review group, but it hasn't asked the review group, and more than that, the Minister hasn't met with the review group, does the Minister not accept that essentially it hasn't done the required preparatory work to come here this morning to actually discuss the amendments? It set up a process that it hasn't even attempted to meet based on what the Minister has just said. And can he understand the frustration of members hearing that?
Yeah, to come back to that point, of course I can understand that. The review group itself has had its own timings in terms of which it's met and taken forward implementation in terms of that. It has not, obviously, in terms of the timing of the group and in the amendments, has not had the ability, has not had the chance to recommend, to have a look at the particular...
Forgive me, Minister, if I can intervene again, but you said that it's their lack of consideration which prevents you from this, but you have not asked them to consider them. Is that correct?
No, I think in terms of some of the amendments which have been brought forward, I think there are a number of issues that they haven't been asked to look at. In terms of some of the other amendments that came forward at a late stage, they haven't been asked to look at that. Hence why I'm suggesting a further discussion with the review group going forward.
And the Minister that it's the Minister's discretion to take interventions at this point.
Yeah. So just, and I appreciate for the time convener on that particular point. I think I mentioned it obviously around about the amendments given the work about the PBSA review group. I'd ask Mr Greer not to press his amendments 548, 549, 559 and 560. If any amendments in this group are pressed, I would ask members of the committee not to support them for the reasons I have set out. Thank you.
Okay. Thank you. Graham Simpson to wind up, press or withdraw Amendment 51.
Well, I'm going to press Amendment 51. Convener, I wrote down the word uplifting at the start of this debate, and that was while members were speaking to their own amendments. It was uplifting because we had virtual unity across the board on what people think ought to be achieved. And then my mood darkened as soon as the Minister started to speak. And I was watching the body language of members and non-members of the committee, and there were lots of head shaking going on as the Minister dug a hole deeper and deeper, and he doesn't appear to have been able to get out of it. And what he seems to be saying, well, in fact he is saying, is that he's not reached a conclusion on many of the amendments in this group. He can't reach a conclusion because the PBSA review group hasn't reached a conclusion on many of the amendments in this group. Mr Johnson wishes to intervene, and I shall, of course, let him.
And I'm very grateful to Ms Simpson for letting me intervene. I would just wonder if the member shares my understanding of the standing orders, that the member in charge, and in the case of a government bill, the Minister, has the ability under standing orders to actually delay stage 2 in order to take further evidence. And given that these are substantive matters, and given that he is stating that it's a lack of evidence, does the member agree with me that perhaps the government's position should be to think about whether it needs to do that, if it's saying that it's a lack of consideration which prevents it from reaching a conclusion at this point, which ultimately stage 2 is about trying to reach a conclusion. I just wondered if the member would share my understanding of the standing orders.
Well, I haven't studied standing orders recently, so I will take Mr Johnson's word for it. But where I think we are today is in a very tricky position for the committee and the committee members who are having to vote on these amendments, because we are in a position where members proposing these amendments have given a great deal of thought to them, and the Minister doesn't appear to have done so because he's hiding behind that review group, which, as Mr Greer, who I will of course let in, as he said, reported 15 months ago, and I'll take the intervention.
I'm grateful, and it's on exactly that point. I was wondering if Mr Simpson would share my confusion at the Minister's line of argument that he can't come to position on these amendments until the review group has come to position on them, when many of these amendments are to implement the recommendations that the review group itself made 15 months ago.
That's quite correct. absolutely right. So where are we? Are we? Yes, of course.
I thank the member for taking the intervention. And can I ask the member if, like me, he's now in a position where he's faced with a very difficult circumstance, which is to try and press an amendment at stage 2, which may or may not carry the support of the committee, but without knowing the position of the government?
That's also correct. Sorry, is Ms Gallagher wanting? Sorry, oh, okay. When I came here on this group, having had a very, very brief chat with the Minister, I was minded, as I often am, to work with him and allow him to do his consultation. But I'm afraid I've changed my mind. I think that if I was a committee member with a vote, I would be voting for many of the amendments in this group in order to put the Minister in the position where he has to deal with them. Whether or not you agree with individual amendments, the Minister has to be forced to the table. Because if he's not, and this may be uncomfortable for the Minister, who I do like personally, he knows that, I've said it many times. If that doesn't happen, I'll tell you what will happen. He's going to hide behind this review group. The can will get kicked down the road. There'll be no amendments passed at this stage. There'll be no amendments passed at stage 3, and that which answers Mr Greer's point. Mr Greer is realistic enough to know that we'll end up with a bill which doesn't address student housing, doesn't address the issue of guarantors, doesn't address the issues raised by Ms Duncan Glancy. So in my view, I'm afraid the Minister has got himself into a position that frankly he should not be in, because he has not given any guarantees that he will work with people with a view, and he's not, I notice he's not intervening on me, so he must agree with that point, with a view to bringing forward amendments at stage 3. Now, yes, I'll take the intervention.
And I think Mr Simpson had said that, and I'd take into the points in terms of the discussion around about with the review group itself. The review group has said meets, it sets its own agenda in terms of that, and I appreciate the point that's been made. And that I have offered to work with members in terms of the individual amendments that they have, and collectively in terms of working with the sector. It's not hiding behind the PVSA sector, it's engaging with them to make sure that amendments that have been raised here, that they're comfortable with, and that includes all the range of stakeholders that I've talked about. So it's not saying that I'm not going to engage in that. I've already mentioned this. I'll engage with members individually in their amendments. I'll engage with members collectively in terms of where the PVSA group. It's not hiding behind the group in terms of us. It's ensuring that we get their full views, including all the stakeholders from different sectors, including students, local authorities, providers and investors in terms of that as well. So I think that's not hiding behind it. It's just taking into cognizance the importance of their views in terms of where this is going forward. So it's not hiding behind anything.
And all that work should have happened already, frankly. Of course.
My colleague, Graham Simpson, of course, has done a lot of work in this particular area of the bill. He's been speaking to students, student representatives, student boards, as I'm sure other colleagues have been doing throughout the process. We know about these issues. We've known about these issues for quite some time. This isn't something new that's been brought to the table that individuals were not aware of. And although I understand and appreciate that the board sets the agenda, given that there is a housing bill, the housing bill has had various different parts of it that relates directly to students, and that was again outlined within the Stage 1 housing report. As the member is frustrated as I am, that after this section is concluded, we will not know what amendments the Minister is seeking to work with colleagues on ahead of stage 3. Yeah. What does that mean in terms of the recommendations that have already been clearly set out in terms of the board? And where does that leave students at the end of the day? I'm wondering if the member has any suggestions or thoughts on that.
Well, Yes, I share Ms Gallagher's frustrations around this. I think the committee, and indeed the Minister, but the committee in particular, is in a pretty astonishing position here of possibly some members wondering what to do. Well, I'm pretty clear, because the Minister has not been clear at all, that the committee really needs to think tactically here. I shouldn't be talking in these terms. We should just know what to do. But tactically, the committee, I think, needs to vote for most of the amendments in this group, unless you're ideologically opposed to something, which you may be. But I think the Minister needs to be brought to the table. He has not committed, despite my actual suggestion in that private conversation that I had with him, that he ought to, ahead of stage 3, bring people, parties, MSPs together to discuss what we could do at stage 3. He's not offered that. He's not actually offered anything.
Just on that point, I think I've offered that.
I'll take the intervention.
Mr Simpson, based on that, in terms of, I think it's in terms of, I've offered to meet with the individuals, I've offered to meet with the group collectively, in terms of, but also with the PBSA group, which includes the major stakeholders. So I think that has been offered.
I think Ms Gallagher wants in as well.
I realise that this could look like an intervention through an intervention, but I'm still none the wiser as to which MSPs that will include, which amendments have been completely thrown out, and which amendments the Minister would likely work alongside MSPs with. And as a voting member, I'm very unclear as to what that direction is, so therefore it leaves the committee, in my view, in a very unclear state as to how we vote in terms of whether the Minister is willing to work alongside some colleagues in their amendments, or whether or not the Government was suggesting to oppose.
Well, that's entirely right. But I'm clear on what I would do. Is if I was voting, which I'm not, I would be trying to get the Minister to engage with this in a way that he has not engaged today. And I think it's a pretty extraordinary situation, to be honest. So I think my position is clear. I've outlined what I think. I thought the way forward was to, I'd hoped the Minister would be coming here today to say, not sure about that amendment, maybe that amendment needs a bit of work. We'll maybe engage with the review group. I'll make sure MSPs can meet the review group, maybe collectively, and together we can agree on some amendments to deal with these issues for stage 3, but he's not done that. So my strong suggestion to the committee, I can't really make it any stronger or clearer, is that you should, if you can bring yourself to, support most of the amendments in this group. Thank you.
The question is that Amendment 51 be agreed. Are we all agreed? No. No, we are not agreed. There will be a division. Those in favour of the amendment? Those against? Thank you. The result of the division on Amendment 51 is 4 for and 3 against. The amendment has been agreed. And at that point, we are going to take a break, a 10-minute break. And we're moving on to the next grouping, which is removal of Part 1. And I call Amendment 85 in the name of Megan Gallagher, grouped with amendments as shown in the groupings. And I point out that if Amendment 115 is agreed to, I cannot call Amendment 361 that comes in the group Information to Tenants because of preemption. Megan Gallagher to move Amendment 85 and speak to all other amendments in the group.
Thank you very much, Convener. It will not come as any shock to members who are present at committee this morning that the Scottish Conservatives are principally opposed to rent controls, as we believe that they will further harm an already delicate housing sector. This Stage 2 consideration is critical for the potential of new investment and purpose-built rental accommodation in Scotland. These changes we make here at committee and at Stage 3 will shape the future of the housing sector. Scotland must be investable, otherwise this Parliament will collectively fail to provide enough supply to meet demand in the future. The pipeline of new build rent projects is now frozen, with a 0% increase in the growth of projects and planning over the past year. Build to rent construction activity has fallen by 26% over the past year as schemes already under development complete. Schemes in planning have stagnated due to uncertainty and investors remain unwilling to commit to new schemes. BTR is an investment opportunity that should be additional to the delivery of private homes for sale, affordable and social housing. It's an opportunity to significantly boost housing supply that has been frustrated by years of sudden policy interventions by the Scottish Government and uncertainty on the long-term system of rent controls. To put everything into perspective, Scotland has delivered just 3,485 build-to-rent-led schemes in over a decade. This compares to 122,279 completed and operational in England over the same period. We are in a housing emergency. This Parliament has declared a housing emergency, and we cannot afford more ill-thought-out policies such as permanent rent controls. I appreciate that members in committee today may not agree with the position that I am laying out to remove rent controls. However, I do believe this is an opportunity to have an open discussion where we talk about opportunities in terms of growing that mixed tenured housing that Scotland desperately needs. Rent controls will not sufficiently address issues facing the private rented sector, and my concern that billions of pounds worth of investment into new build homes will be held back due to this move. I only need reference the last time rent controls were introduced. According to a survey of landlords by the Scottish Association of Landlords, 17% of landlords said that they sold their properties or were considering selling their rental properties. Rent controls have discouraged landlords from investing in the upkeep of their rental properties, and according to the same survey, 44% of landlords have reduced or stopped spending money on maintenance and improvements since rent controls were introduced. It's also become more difficult for new renters to find housing. According to the Scottish Government, since the rent control introduction, the average time it takes for a new tenant to find a property has increased from 12 weeks to 16 weeks. Reduced supply, disincentive for investment, exacerbating the housing problem and unintended consequences could await the private rented sector through rent controls. For these reasons, I have tabled the amendments in front of members today. I ask members to think about this decision carefully and what impact rent controls could have on those who provide housing, as well as opportunities to ensure that we have enough housing stock for people who need homes. I note that the Minister has supported the removal of Section 13, which relates to exemptions, and it's probably the only area in this section that we could find consensus in relation to rent controls being made permanent. But of course, members will have amendments on exemptions. I myself have amendments on exemptions, and again, that debate must be made clear throughout this process, as we need to try and tease out from the Minister what exemptions, if any, will be applicable and which ones, of course, he is sympathetic to. I understand that there's also the ongoing consultation in relation to exemptions, and I hope the Minister will realise that he does have his work cut out from him trying to navigate the balance of this bill and its processes. Convener, I'll leave my comments there. Thank you.
Thank you. Would any other members... Could you move your amendment?
Sorry, I moved my amendment.
Thank you. Does any other members wish to speak? Minister.
Thank you, Convener.
Amendments 85 to 89, 91 to 93, 98 to 101, 107, 108 and 110 to 115 would remove sections 1 to 20 of the bill. They would collectively remove the provisions of the bill that provide for the establishment of rent control areas and associated rent controls. With the exception of Amendment 107, each of these amendments would significantly impede the implementation of provisions of the bill relating to rent control areas. Whilst I recognise that Megan Gallagher has concerns about the provisions that allow for the establishment of rent control areas, this Government is committed to making provision for this, recognising that people who rent their homes are more likely to live in poverty, be financially vulnerable and live on low incomes compared to those who own their home either outright or with a mortgage. The rent controls provided for the housing bill are just some of the measures we are taking to improve lives and work towards achieving our goal of ending child poverty in Scotland. Rent controls will support tenants to remain in their homes by helping keep rents available. Rent controls exist in most European countries, and I think that they also allow for investment in the BTR, MMR and PRS sector, and I think the proposals we've brought forward achieve that balance of one, around about the rent controls, but two, allowing investment to come in to the sector also. Megan Gallagher's Amendment 107 would remove the power in Section 13 of the bill to exempt properties from rent controls. I support this amendment because the power in Section 13 can be removed in consequence of my Amendment 329, which will be considered in a later group. My Amendment 329 seeks to move the power in Section 13 into a different bit of legislation. As my amendment would insert the same power into that other legislation, the power in Section 13 would no longer be needed. I therefore support Ms Gallagher's Amendment 107 on that basis. Turning to the amendments in this group to seek to remove provisions of the bill that modify the rent controls, Amendment 116 would remove Section 21, which provides that the rent payable for a private residential tenancy must not be increased during the first 12 months of a tenancy. Section 21 applies to properties that are not in a rent control area, as well as exempt properties that are in a rent control area. It provides tenants with security of knowing that the rent they have agreed to start tenancy will not increase during the first 12 months. Amendment 116 would remove that clarity and certainty for tenants. For that reason, I cannot support it. I would urge Ms Gallagher not to press this amendment. Megan Gallagher's Amendments 117 and 118 would remove Sections 22 and 23. These sections make provision to ensure that where a proposed rent increase is referred to a rent officer to the First Tier Tribunal, the rent will not be increased by more than the amount originally proposed. Under these measures, the rent would not be set at the lower of either market rent or the rent increase proposed by the landlord. Again, these provisions would apply to properties that are not in a rent control area, as well as exempt properties that are in a rent control area. Sections 22 and 23 are designed to address concerns about the current process, which would enable a rent officer or the First Tier Tribunal to increase the rent to open market rate, even though it is higher than the rent increase proposed by the landlord. Without these changes, tenants may be reluctant to pursue their right to refer to a proposed rent increase for independent adjudication. I cannot therefore support Amendments 117 and 118, which would remove this additional protection for tenants. I would therefore encourage members to support Amendment 107, but I would urge Megan Gallagher not to press her other amendments in this group. If any of these other amendments are pressed, I would urge members of the committee not to support them for the reasons I have set out. Thank you, Convener.
Thank you. Megan Gallagher to wind up. Press or withdraw Amendment 85.
Thank you very much, Convener. Although I understand the Minister's position and indeed the Scottish Government's position, it's certainly not a position that I support in principle. I do believe that rent controls will punish the private rental sector at a time where we need all different sectors of our housing market to work together in order to provide safe, secure homes for people during the housing emergency. I think that is something that needs to be worked on collectively. And it's also something that the government needs to be aware of, that should they bring in rent control measures, it will potentially mean that landlords will leave the sector. In addition to the points that I have raised within my opening remarks, I do believe that the government hasn't taken into consideration the fact that during the last time that rent controls were introduced, it did mean that people waited sufficiently longer in order to find a property. And I would ask the Minister that should rent controls not work, and I do have my doubts that they will, that other options will be looked at in order to make sure that we're not decimating a sector that has already suffered at the hands of knee-jerk policies from the Scottish Government, but look at ways that we can naturally reduce and bring down rents by making sure that we're increasing the housing supply across all different areas of the housing sector. I'll leave my comments there, Convener, but I will be seeking to push Amendment 85.
Thank you. The question is that Amendment 85 be agreed. Are we all agreed? No. We're not agreed. There will be a division. Those in favour of Amendment 85 and those against? The result on the division on Amendment 85 is 2 for and 5 against. The amendment has been disagreed. We're going to move on now to the next grouping, which is taxes and local government finance. I call Amendment 519 in the name of Ross Greer, grouped with amendments as shown in the groupings. Ross Greer to move Amendment 519 and speak to all amendments in the group.
Thank you, Convener. I'll be moving that amendment. I should say from the outset that this will be, I've tried to keep it as concise as possible. This will be a lengthy contribution, but members will be glad to hear that I don't come up again for a number of groups, so they won't need to hear from me again for probably at this rate of progress a few weeks. So to start off with, on the group of amendments I've got around council tax revaluation. So members of this committee will be aware, more than anyone else in Scotland, I would imagine, just how discredited our council tax system's become after 34 years. We are long overdue making progress on this. I believe, my party believes, that an outright replacement is required, but views on that issue vary. And this bill isn't the right vehicle for that. But I do think it's an appropriate opportunity to make progress on what I believe is a genuinely technical but fundamental issue, that of the valuation rule. Because regardless of our position on whether taxes are too high, too low, whether they catch the right people or the wrong people, I think we do all agree that it's quite ludicrous for the system to have reached the point where most people in Scotland now pay the wrong rate of council tax. So this group of amendments would allow Parliament to finally resolve that issue, the issue caused by the continued use of the 1991 valuations. So Amendment 462 makes explicit that when council tax bands are varied under Section 74 of the Local Government Finance Act, the number of bands can be changed. This empowers ministers to follow the Welsh Government's recent addition of bands to make their council tax system more proportionate and progressive. Because as well as individual property values changing in the last 34 years, the range of values for residential property in Scotland has widened significantly. It's not proportionate for a house that's worth 15 times less than another to pay just 3 times less in their council tax, as is currently the case with your average property values in Band A versus Band H. So updating the valuation rule but sticking with the existing set of bands would, I think, be a job half done, which is why I've brought forward this amendment. The key amendments in this particular section, though, are 463 and 464. So these would mandate that ministers undertake a council tax revaluation exercise with updated values to come into force no later than the 1st of April 2029, so the 29-30 financial year. 463 mandates regular subsequent 5-yearly revaluations. 464 is a one-off exercise. Now, my preference is very much for 463 because I wouldn't want us to resolve this issue now and then to have to wait another 34 years as the same problem repeats itself. But I've put both down because I recognise the difficulties inherent in this and the reason why it's taken us 34 years, and I'm keen to seek Parliament's view on that. Additionally, they do specify that ministers can make transitional arrangements to make any changes in household council tax liability more manageable, and there's particular reference to those with low and fixed incomes there. Amendment 478 is a consequential amendment to 463 and 464, so it applies the affirmative procedure to any regulations that are made under those amendments. I would highlight at this stage, so far as I've been able to tell, and that Spice have been able to tell, Parliament's never actually voted on the question of revaluation before. And I really don't think it should have become as political as it has, and I actually fundamentally don't think it is as political or politically fraught as we all fear. It is right that we debate and that we disagree on the more fundamental questions of reform or outright replacement of the council tax. But I think we do all agree that just using accurate data is appropriate here. We wouldn't tolerate a system of income tax where most people were paying the wrong rate, and it can't be justified for council tax either. And I'm sure that the government will say that there's an engagement exercise underway, but no one disagrees with revaluation. And we've done consultation, we've done listening, we've done working groups, we've done cross-party agreements before, and they've not moved this issue forward because Parliament has never actually had the question put to it and had the opportunity to vote for it. So after 34 years of this problem getting worse, to a stage that I would suggest is now intolerable, I want to give Parliament the opportunity to address this technical aspect of it. And I believe that if we do that, it would give us more space to address those more substantial areas of political disagreement, appropriate political disagreement. Moving on from that, though, on council tax arrears, so my amendments 542 and 543. 542 requires ministers to review the scale and the impact of council tax arrears and then state what action they intend to take as a result. And this is because I want to give the government a bit of a nudge to address this issue. Council tax arrears are written off after 6 years in England, but in Scotland it's 20 years. And that 20-year clock resets every time the individual with arrears engages with the system. So essentially, it's a never-ending process. Every time that they engage with the system, as they are obliged or pressured to do, that 20 years resets itself. Other forms in debt of Scotland, though, are typically written off after 5 years. So there's a major discrepancy here. The Robertson Trust have done a substantial report on that issue that I sent to members, albeit last night. Amendment 543 requires ministers to review the impact of joint and several liability for council tax arrears on domestic abuse victims and survivors, and then again to state what action they intend to take. And this is because of situations I'm familiar with, and I'm sure others are as well through casework, of survivors of domestic abuse ending up having the arrears, having to pay off the debt of their abuser, which I think we can all agree is completely inappropriate, but the system as it stands does allow for that to happen, and that is happening. So I want to encourage the government to review that and look towards ways that we could resolve it, because I think it is probably resolvable through some relatively simple measures. Moving on from council tax, on land and buildings transaction tax. Amendment 465 mandates that ministers extend LBTT liability to open-ended investment companies in a way that mirrors the liability of unit trusts. So OEICs are a type of investment fund. They are similar to a unit trust. The power to apply LBTT to this particular form of company was included in the 2013 LBTT Act, but the regulations to activate the provision were simply never brought forward. And Amendment 467 is almost exactly the same, but this time in reference to residential property holding companies. Now, RPHCs are just a tax avoidance scheme, and it is particularly odd, I think, that the Scottish Government gave itself the power to apply LBTT to them in the 2013 Act via regulation, but in the 12 years since has not brought forward those regulations. So I would be very keen to understand the government's position on that, but I just don't see any justification to exempt these two company types from paying the same tax that anybody else would. If any of us were buying a property, anytime any of us have bought a property, we pay LBTT quite rightly. I can't understand why, particularly RPHCs, which are a notorious tax avoidance scheme, do not have to pay because the regulations have not been brought forward, or do not have to pay by and large. There will be situations where for other reasons they might have to. Amendment 547 mandates a new LBTT band be created for properties that are sold for what would the starting rate of £1 million or more. And that's reflecting the fact that, take for example, Newston House, which is on sale just down the road from here at the moment, offers over £3 million if you want just part of the estate, offers over £15 million if you want the whole estate. I don't think should be paying anyone purchasing that, I don't think, should be purchasing it at the same rate of LBTT that a townhouse in the new town, for example, at 800 or 900 grand should. I think the system requires a bit more progressivity in it. Amendment 466 removes the current LBTT exemption for foreign militaries. Now, there's only one government in post-war Scotland that's had a significant presence in Scotland. Of course, that's the United States, and they can more than afford to pay LBTT if they're purchasing any additional property, regardless of the views that some of us might have about whether indeed we would want them to do so. Now, Additional dwelling supplement amendments. So 468 requires ministers to introduce a relief or an exemption for the purpose of an additional property where it's to be used by someone who doesn't have the capacity to take on the obligations of home ownership but is able to live there themselves. So you could potentially do that with reference to receipt of disability benefit like the DLA. This is the result of casework that I've been engaged with. Exactly this situation is the case. Clearly this is not the kind of situation that the additional dwelling supplement is designed to catch, but at the moment it is catching individuals who are purchasing property on behalf of typically family members who have the ability to live independently but not the ability to be the homeowner themselves. Amendment 469 lets ministers set a scaling rate for the additional dwelling supplements, so your liability would be greater if it's the third property, the fourth property, etc. So it progressively taxes those who are most able to purchase additional property, which is seeking to discourage the accumulation of large portfolios. Amendment 493 allows for the setting of a surcharge for companies who are purchasing dwellings. This would allow ministers to align LBTT in Scotland with the 17% company rate for stamp duty in England. I think it's unusual that we've created a system in Scotland of LBTT that's a bit more progressive than stamp duty in England, but that this step was missed out. There's more flexibility in the English system because they can distinguish when it's an individual versus a company. And I think having that flexibility in the system here, regardless of the debate we might have through annual budgets about the appropriate rate to set for either individuals or companies, I think being able to distinguish between the two of them is useful. LBTT and ADS, as it stands, are currently relatively blunt instruments. 544 allows ministers to apply a further surcharge to ADS in the rent control zones that this bill would establish. So it disincentivises the purchase of properties in areas where there is this acute housing pressure. I think it's particularly relevant. The reason I brought this forward is because of the circumstance in rural and island communities where it is short-term lets and holiday homes that are the key driver of local housing crisis. So I'd point to Lochranza on Arran that Katie Clark and I represent, where around 40% of houses in that community are either short-term lets or holiday homes. That is the driver of the housing crisis in that area, and it results in young people having to leave the community that they were brought up in because they are simply unable to find a home for themselves. Amendment 519 requires councils to state whether they want that surcharge created by 544 to be applied to a rent control area when they're recommending it be designed under Section 2 of the bill. So it allows ministers to consider that local context, and it reflects that this measure would be more appropriate in some rent control zones than others, i.e. particularly those ones where it is very obviously holiday homes and buy-to-let, short-term lets that are the main driver of the issue. So Amendment 545 similarly allows ministers to apply a further surcharge to ADS, but this time in national parks, and that they have regard to the view of the National Park Authority when doing so. Recognises the unique pressure on communities in our national parks from second homes, buy-to-let landlords and properties that are being acquired and used as short-term lets in particular. And I'd point to the fact that at the moment about 1% of properties in Scotland are second or holiday homes. But in Loch Lomond and the Trossachs National Park, it's 5 times as many. In Cairngorms, it's 12 times as many. And in some particular communities, I think Braemar is probably the clearest example of this, it's 20 times as many as the national average. Both national parks have set out in their strategic planning documents. So in the Cairngorms case, it's the partnership plan, section 7 of that, just how significant the negative impact of this is, the pressure it puts on communities who actually live in these parks. You can find similar comments in Loch Lomond and the Trossachs housing strategy as well. Amendment 546 lets ministers apply a further surcharge to ADS when the buyer is not ordinarily resident in Scotland. So this seeks to tackle the issue of overseas property speculation. So the UK has now actually become the world's #1 destination for overseas property investment. So essentially property speculation from outside of the country. It is a huge problem UK-wide. I'd flag at this point, though, that Revenue Scotland doesn't actually collect this data for Scotland. So we are relying on the UK-wide figures and anecdotal examples in this case. I think that's another area that should be addressed, not quite for this bill, but I would encourage the government to actually start collecting this data when it is an overseas buyer of a property, particularly those from tax havens. The number of properties being bought in Scotland from what are recognised by the UK as tax havens has doubled in the last couple of years, and we should be disincentivising that. Amendment 193, moving on to a different topic entirely, is something that was raised with me by local government colleagues. So 193 allows for housing revenue accounts for the purpose of accounting for council housing to budget for transfers from the local authority's general fund. So this is just what I think is a pretty simple matter of fiscal empowerment for local government if they want to top up their council housing budgets to allow for extraordinary investments if they have a particular reason for doing so. And Amendment 194 removes the requirement for ministerial approval for local authorities to transfer from the general fund to their housing revenue account. I'm not aware of a single instance where ministerial consent has actually been withheld when it's requested, but this requirement's created a lot of confusion in some local authorities, and I've heard from officers who believe that transfers were not possible because of it. But in any case, even where it is possible, as it stands, it's currently just a huge waste of everyone's time, the officers involved, the councillors, the minister and his officials, that ministerial consent is required for what are often very routine transfers. I think we should trust local government to manage its own finances and to manage its own risks on this. Non-domestic rates. So Amendment 459 imposes an NDR surcharge and prohibits NDR relief or exemptions for short-term lets. So again, reflecting on the experience, particularly some of the communities that I represent, where it is Airbnb-style short-term lets for tourists that are really driving local housing crises and particularly pushing young people out of very, very fragile rural and island communities. Yes.
Thanks for taking the intervention. Obviously, in the rural areas that we represent, to the local economy, short-term lets are really important. And I just wondered whether the removal of the NDR and the, additional surcharge would then make those businesses that are very small businesses actually not then able to apply for small business rate relief, which would actually be quite detrimental to that economy.
I'm grateful to the intervention. I think that there's a much wider point there of the small business bonus scheme having been reviewed by the Scottish Government, or reviewed independently for the Scottish Government by the Fraser Vallender Institute, who could find no measurable positive economic impact from it. So I actually think that the small business bonus scheme needs redesign. So I do agree that small businesses should be supported in the tax system as a way to do that through exemptions, reductions, etc. As it stands, we spend about £250 million on the SBBS every year. And in many cases, it's actually not even small businesses. It's not a business any of us would recognise as small who receive it, because it's not a particularly well-designed scheme. But on the point specifically that Rachel Hamilton raises, so this is very much related to my amendment 461 as well. So at present, a short-term let would pay 200% council tax if it's available to let for fewer than 140 days a year, or if it's actually let for fewer than 70. But when it passes that threshold, it moves from a position where it's paying double the rate of one tax to moving into non-domestic rates, where it potentially qualifies probably for the small business bonus scheme is the most common, where it can actually end up paying none at all. So we have a system at the moment that I think has two contradictory aims and a relatively arbitrary threshold between the two of them, and we're not getting that balance right, particularly in areas where, much as I take on board the point of the importance of short-term lets to the tourist economy, the most common bit of feedback I hear from employers, from businesses in these areas, is their inability to recruit staff to run their business because there is no permanent housing available for them. So Lochranza on Arran being the perfect example, 40% of housing is either a holiday home or a short-term let, which makes it incredibly challenging for local employers to actually find the staff to work in bars, restaurants, cafes, other leisure facilities, for example. So moving on, because I'm recognising how much time I'm taking with this group, the infrastructure levy is covered by Amendment 550. So Amendment 550 repeals the sunset clause, which is currently in place for the levy from the provisions in the 2019 Planning Act. So the repeal extends only to housing developments because of the scope of the bill, but Parliament's ability to replace or complement the existing framework of planning obligations is set to expire by the summer of 2026. I think we should all probably look back and reflect on why we put a sunset clause into that bill because the rationale for it was not particularly clear. This expires, the infrastructure levy power expires in the summer of 2026 unless regulations are made. And at that point, we will have lost the ability to bring in an infrastructure levy at some point in the future if we believe it's appropriate, unless it's recreated through primary legislation. And given that it is already in legislation, I suggest that's inappropriate. So I accept that the government's decided not to proceed with the infrastructure levy at this point, but unless regulations are laid or this amendment is passed to nullify the sunset clause, the power just disappears completely. And we took the view collectively that such a power was required in 2019. I think it would be wasteful to let it expire, and then if we decide a few years from now that, oh no, in fact, an infrastructure levy would be justified, we need to recreate it through primary legislation. The current system of developer contributions under Section 75 is applied exceptionally unevenly. And it clearly disadvantages smaller and rural and island authorities because they just lack the in-house expertise and the legal capacity to secure these agreements. So, for example, 10 councils had no Section 75 agreements last year. These are the essentially voluntary contributions that developers make to a local authority. 16 councils had fewer than 10 of those agreements each, and the relative value of them varied massively. Only half a dozen had more than 10. And I'm happy to share more information on that with colleagues if they would find it beneficial. But the rationale behind the infrastructure levy is that building houses does not mean building communities. All sorts of other infrastructure is required to turn a housing estate into a successful functioning community. You need funding for the provision of schools, of health centres, of public transport infrastructure, roads, pavements, active travel, etc. And that it's right for developers to make a contribution towards that, because they are the ones building the houses, but not building the community as a whole. We can have that debate again. I suggest it's for the next Parliament to have, because I accept the government's made a decision that it's not introducing an infrastructure levy for now. I think it would be a real shame if we allowed the sunset clause to take away our ability to have this debate again in the future without having to go through the cumbersome process of recreating something that we have already recreated in primary legislation because we've allowed it to lapse. And you'll be pleased to hear, Convener, that that is the end of my contribution.
Thank you. Ross Greer to move Amendment 519.
I move. Thank you.
Thank you. Graham Simpson to speak to Amendment 74 and all other amendments in the group.
Well, thanks very much. I won't address all amendments in the group because it's that might take some time, but I will address my own. I mean, you'd expect a group with taxation in the title to be dominated by the Greens, of course. And, sure enough, they haven't disappointed. So my one amendment is Amendment 74. It deals with students again. It would exempt students from paying council tax until they have graduated. It directly amends the Council Tax Discounts Scotland Consolidation Amendment Order 2003. I put this forward after having presentations from students about this very issue. It really is as simple as that. So it's whether members agree or disagree, and I think it's worth voting for. Now, Mr. Greer has raised a number of issues. You may consider that this bill is not the place for them, but he's managed to air his views. One which calls for a council tax revaluation. Now, of course, we have a system where property values for council tax purposes are based on the 1991 values. That is clearly absurd, but if you were to change that, if you were to revalue, there will be winners and there will be losers, and that is no doubt why this will not pass today. Because there will be losers. Yes, I will.
I agree, absolutely. Of course, there are winners and losers from any revaluation. I would argue there are winners and losers right now, and the people losing out right now, the people most likely to be paying more than they should if it was an up-to-date valuation being used, are often those in the smallest or the least valued properties, and often on the lowest incomes as well. And we'd appreciate that both versions of this amendment include a requirement for ministers to look at transitional relief, particularly for those on low and fixed income. So the classic example of the pensioner living in a large property, but on a low income that would make it harder for them to pay an updated and likely higher council tax bill, because that's not what I'm proposing. What I'm proposing are for them to have appropriate reliefs, but for those who are frankly paying much more than they should, and who are often those who are already struggling the most, to get a little bit of justice here.
Yeah, I mean, I think if you just look at the revaluation issue, it's clearly, I mean, it's quite absurd, but this may not be the place to do it. I think, I mean, frankly, Parliament's been playing around with this for far too long. I think it comes into the too difficult pile, and that's why probably parties won't deal with it. But it needs to be dealt with, and it's probably one for the next session. I'm sorry to say that, Mr. Greer, but that's the reality. I'll leave it there.
Megan Gallagher to speak to Amendment 132 and other amendments in the group.
Thank you, Convener. And similar to Graeme Simpson, I don't intend to speak to every amendment in this group because I know that time is becoming precious as we head into these future sections. My Amendment 132 is a probing amendment regarding the Land and Buildings Transactions Tax. The Scotland's budget for 25-26, published in December, announced an immediate increase in the surcharge in land and buildings transaction tax on the purchase of second and rental homes from 6 to 8%. The Scottish Conservatives, of course, were opposed to this. But interestingly, when looking at the IFS, they have rightly, I think, in my view, stated that despite the publication of a tax strategy alongside the Scottish budget, it's not yet clear what the Scottish Government's vision for tax policy is, but increases to LBTT are not consistent with any economically sensible strategy. And I think that's where we are when we're looking at various different taxes, and I do believe that it is imperative for the Scottish Government to actually finally come clean in terms of what its tax strategy is and what it will be in the future, so therefore that we can make clear assessments in terms of what their thinking is and what their objectives actually are. The Amendment 132 in itself would modify the land and buildings transaction tax, changing the number of dwellings from 1 dwelling to 2 dwellings, altering the transaction to third homes. So in my view, it would act as a partial relief for LBTT for smaller home owners. I know my colleague Rachel Hamilton will expand on arguments in relation to LBTT as she's tabled amendments 224 and 225. But interestingly, I do want to pick up on the point raised by Ross Greer in relation to council tax. I do agree with Graeme Simpson. It is absurd that we're looking at valuations from 1991. However, the committee, the Local Government Housing Planning Committee, has put forward an inquiry. We obviously heard from various different stakeholders. We heard from the Minister in that respect as well in relation to council tax. But I don't believe enough time has been afforded to the committee to undertake the inquiry or to perhaps reach a consensus in terms of what the next stages of council tax reform would look like. I understand that Ross Greer has obviously tabled these amendments. I think he's articulated his points that he wishes to raise, but I don't believe the bill is the correct mechanism to do so, given that it is such a wide-scale topic, given that there is various different views, not just amongst political parties, but amongst stakeholders and groups impacted as well. And I think a wider piece of work would need to be undertaken, not just by committees, which we've already tried to do, but indeed the Scottish Government would need to decide whether or not they were going to bring forward legislation on council tax reform. That obviously... Yes, I will.
I'm very grateful to the member for taking the intervention, and she talks about a wider piece of work needing to happen. I always welcome more work being done on tax policy, but we should recognise that a really significant piece of work was done on this on a cross-party basis, but led by the Scottish Government in 2015. And it wasn't the first time that this issue had been revisited since 1991. everyone agrees, as we've already heard this morning, everybody agrees the system is absurd. Everybody agrees that revaluation in some way, shape or form needs to happen, but that the government, no government has ever tabled a vote on it. And that if Parliament doesn't agree at this opportunity, then there certainly is not going to be another one before the next election.
Absolutely, but again, I think that is on the, it's too hard, it's too difficult to sort out bundle that we've been dealing with the Scottish Government for many, many years. And, I don't believe that we have sufficient time to really look into what council tax reform would look like. As I said, the principle it may well be supported, but in terms of what that would look like and what party positions would therefore be, I think that would be a wider discussion. That would need to be legislation brought forward by a government, and therefore for parties to make their own considerations following that wider piece of work. But I don't take away from the work that's already been undertaken and, of course, the assessments that were therefore concluded as part of that work. Convener, I think I will leave my comments there. But again, in terms of 132, probing amendment for LBTT. Thank you.
Thank you. Rachel Hamilton to speak to Amendment 224 and other amendments in the group.
Thanks, Convener. Amendment 224 modifies the Land and Buildings Transaction Tax Scotland Act 2013 to repeal Schedule 2A, which makes provision for the ADS, and Section 26A, which introduces that schedule. Other changes to that Act remove references to Schedule 2A. We all know what ADS is, but I want to set out that I believe that we shouldn't be doing things that are more harm than are more good. And we know that in the recent budget, the SNP made the decision to increase the ADS from 6% to 8%. And I want to just quote what the IFS said, the Institute of Fiscal Studies, who published the assessment of Scottish tax strategy and policy. And they noted that taxing property transactions is an exceptionally damaging way to raise revenue. They went on to state, the increase in the ADS makes a bad tax bigger and even more harmful. The IFS also highlighted that the increase in ADS will make it more difficult and expensive for those who remain in the rental sector, tenants who are likely to face higher rents as a result of the policy, as well as landlords. It's highly damaging. It's a vindictive tax for the housing sector. It unfairly targets landlords and second home owners without any consideration of wider implications of the tax or any meaningful solution to address the root cause of our housing crisis. Amendment 224 aims to restore a functioning housing market where the private sector can work with the government to tackle housing shortages. On Ross Greer's amendments, I just want to speak to those, if I may. He did kindly take an intervention from me, which sort of he addressed what I asked. However, I think this is not the place for these amendments because he didn't actually address how, through those amendments, he can achieve his aims. And I think, in terms of my point that I tried to make, that if these amendments were adopted in terms of removing the NDR and putting an additional surcharge on the rates, it would really mean that accessing the schemes such as the small business bonus scheme would be impossible because it's going to mandate higher rates specifically for a really important self-catering and short-term let sector. And sure.
I'm very grateful. Rachel Hamilton questions how my amendments would achieve the aim I'm setting out. As evidence, I would highlight that, as has already been pointed out, the additional dwelling supplement as it stands in this Parliament has been doubled from 4% to 8% at the request of the Greens in budget negotiations. Between that and doubling council tax on second and holiday homes as well, there were 2,500 fewer ADS qualifying purchases last year, i.e. 2,500 fewer homes were bought as second or holiday homes last year. Is that not evidence that the objective I'm looking for here, which is to push these houses back into the market for people who will live in them permanently, is achieved through tax measures such as this?
Well, I want to point out that I think the figure for self-catering properties is around about 0.8%. Of Scotland's total housing stock, and that is compared to 3.4% for empty homes and 0.9% for second homes. And we're talking about small landlords here, not large investors. I just think that whilst your aim is laudable, it's not dealing with the root crisis of the housing shortage. It's just pushing people into a detrimental financial situation that are small landlords and not actually dealing with the situation. Yeah.
Rachel Hamilton for giving way, and does Rachel Hamilton agree with me that with rent controls on top, it will tend to be smaller landlords who will leave the sector, not allowing, and particularly in rural areas, for people to utilise those homes perhaps for local rural economies, which is very important?
I absolutely agree with Megan Gallagher. I mean, the self-catering business, for example, in my own south of Scotland area, it's really important. It makes up a crucial part of the bed stock and drives that local rural economy. And I know that speaking to many people across Scotland, that they've had a really difficult few years with the short-term let licensing and other legislation that's come down the road. And I do fear that they will, it'll be the straw that breaks the camel's back. So, I mean, if I was a member of this committee, I wouldn't be supporting Ross Greer's amendments because I just don't believe, even though he's tried to explain that these would achieve what he's trying to aim to achieve what he's trying to do here. Thank you.
Thank you. And I call myself to speak to amendments 255 and 492. Housing cooperatives are a largely untapped resource when it comes to solving the housing crisis and reducing burdens on health and social care budgets. And given the huge imbalance between the supply and demand for social homes in Scotland, it's vital that we do everything that we can to build up the sector. At present, housing co-ops face significant barriers to getting started and scaling up. One of the biggest issues they face is exposure to land and buildings transaction tax and additional dwelling supplement. LBTT makes it harder for co-ops to purchase sites so that they can get going. And ADS means that they have to raise significant funds before they can expand. So not only is the cooperative sector being restricted before it can house anyone, it's being prevented from meeting the needs of local communities when demand has clearly been established. My amendment 492 for the LBTT exemption and 255 for the ADS exemption removed these burdens, which will allow the cooperative sector in Scotland to grow, provide more people with affordable homes, and in doing so, bring Scotland closer to solving the housing crisis. These amendments also contain what the legislation team informs me is Scotland's first ever legal definition of a housing cooperative. Now, I've consulted with key stakeholders, including Cooperatives UK and the Confederation of Cooperative Housing, to draw up a watertight set of rules that cooperatives and their structures have to meet. And these will ensure that housing cooperatives are run properly, meet the needs of their tenants and owners, and cannot be abused. For example, I've included a specific provision for what a prospective tenant should be. This is intended to close a loop that has arisen in legislation in England, where co-op members have been using the vagueness of the term to assign tenancies to family members or close acquaintances, instead of going through the proper processes. And this has had the effect of locking people out of cooperatives in areas where housing costs are high, such as London. And my work on this definition will mean that we do not have the same problems here in Scotland. Would any other members wish to speak? Mark Griffin.
Thank you, Convener. I just wanted to speak on the tax proposals in this group. Ross Greer and the points that he's making, I don't necessarily disagree. In fact, I agree with a lot of what he's saying about the ridiculous nature of a 1991 valuation system, about a lot of the other points that he's been making as well, and I applaud him for his efforts. I would simply say that what he is seeking to do with these amendments essentially put a bill within a bill, and I think they would stand on their own as essentially a domestic property tax bill, would benefit from the level of scrutiny and engagement that we would from a standalone bill that I think these proposals need and deserve. So while supporting the principle of what he's trying to do, I do think they need a legislative vehicle of their own to give it the proper scrutiny that they deserve. Yep, certainly.
I'm very grateful. And I agree that a bespoke bill on these issues would be preferable, but in 34 years we've not had that from no government of any colour, both pre or during the devolution era. And I'm wondering if Mr Griffin thinks such a bill is likely, clearly not in the remainder of this session, but next session either. And if he agrees with me that such a bespoke bill is not likely, is it really the case that it's more important to risk not doing this at all than to do it in this manner, particularly given that everyone agrees that revaluation in some way, shape or form is clearly necessary?
Whether a government brings forward a bill in this session, the remainder of this session or not, I think it's moot. Mr Gray, you've brought forward these amendments within this bill. You similarly could have brought forward your own private member's bill in the absence of government action for the last 34 years, in which, again, I think absolutely the nature of the changes that we're talking about, like I said, a number of them I support in principle, need to be debated and scrutinised in a bill of their own, and it's purely for those reasons that I feel that I can't support them as amendments to this piece of legislation. But I applaud the work that Mr Greer has done to try and get them into this piece of legislation. But thanks, Convener.
Thank you. Minister.
Thank you, Convener. Contributions, and I'm afraid I've got some lengthy speaking notes on this one as well, so please bear with me. Some of the amendments in this group make changes to the Land and Buildings Transaction Tax, LBTT, council tax and non-domestic rates. Changes to these taxes would normally be taken forward in a tax-specific legislation in line with our framework for tax principles and tax strategy. And I think one of the key things that's been mentioned about is about revaluation. Mr Green, I think obviously it would be important to understand what I suppose the structure of that revaluation would be on that particular point. But I'll come on to that further on in the discussions. Tax-specific legislation in line with the framework for tax principles and tax strategy. Any such proposed changes would be expected to follow focused taxpayer and stakeholder consultation. It would also normally involve collaborative working with Revenue Scotland and local government to ensure effective administration and compliance. Proposed changes are then considered by the relevant committee. For LBTT, this approach is reflected in the announcement of a review at the Scottish Budget 25-26. This review is underway and will incorporate a broad range of issues that have been highlighted to us by a range of stakeholders, including some of the issues set out in these amendments. With this in mind, I would ask members not to support amendments relating to the Land and Buildings Transaction Tax. For similar reasons, I would ask members not to support the amendments in this group that make changes to the council tax and NDR regime, with a section in the amendment that I'll discuss later, which would remove a cap on powers to vary council tax on occupied dwellings. Yes.
Thank you. It would be beneficial, certainly for me, I think it would be beneficial for the Government to put it on the record. If the Minister could just confirm, does the Scottish Government think that a revaluation exercise is necessary after 34 years? And if so, how does it intend to go about that?
I can't speak for the First Minister, and at this time I think it's been discussed in various debates and whatever regarding the importance of that in council tax reform. Whatever that would undertake, I think that would have to be, as said, undertaken in a tax-specific legislation and also in consultation in that regard. So I'll come on to Amendment 519 in the name of Ross Greer, which amends Section 2 of the bill to require local authorities, when stating in a report whether it recommends designating a rent control area, to also state whether it recommends a high rate of additional dwelling supplement ADS should be payable in the area. Amendment 74, in the name of Graham Simpson, would modify council tax laws so that it applies until a student has graduated from, rather than just completed their course. Graduation ceremonies can occur weeks or even months after a student has completed their course, and in some cases individuals may defer their graduation. This issue raises two concerns. The first is that amendment extends council tax discounts to those who have in practice finished their student studies and potentially entered the workforce but who have not yet formally graduated. The second is that the lack of a consistent meaning of graduated creates enforcement difficulties for local authorities. I cannot therefore support this amendment and would ask the member not to press it. Amendments 191, 192, yes. Yes.
Thank you. I hear what the Minister's saying. Clearly people can graduate long after finishing their course, so I accept that point. But does he accept the general principle of what I'm trying to achieve, irrespective of the details?
In terms of some of the drafting I've mentioned there, I'm happy to engage with the member further on that particular point. Amendments 191, 192, 192A, 197 and 198 and Naomi Frost-Greer seek to devolve responsibility for setting council tax for unoccupied dwellings. I agree in principle with the proposal to remove caps imposed on the variation and modification of council tax for unoccupied dwellings. The Government is committed to delivering a fairer housing and taxation system. In line with that commitment, we work closely with local government through the Joint Working Group on Sources of Local Government Funding and Council Tax Reform to deliver the first council tax premium on second homes from the 1st of April 2024. Local authorities should have greater flexibility over the council tax that applies in their areas in relation to unoccupied dwellings. The pressures associated with second homes vary significantly across Scotland. In some areas, second homes reduce housing availability, and others they may contribute to local economies. These are decisions best made by local authorities based on the needs of their local communities. Amendment 191 would remove a cap on increasing council tax for unoccupied dwellings by means of regulations under Section 33(1) of the Local Government Act 2003. I agree with this and ask members to support this amendment. Amendment 192, along with amendments 192A, 197 and 198, would remove caps and powers to vary and modify the application of council tax for unoccupied dwellings. Whilst I agree with this, I cannot support these amendments because they would also impose duties on the Scottish Ministers to exercise powers in a particular way. I would offer, however, to work with the member ahead of Stage 3 with a view to removing the cap on the power of local authorities to modify the application of this tax. Amendments 462, 463, 464 and 478 in the name of Frost-Greer would commit to a re-evaluation and modify valuation bands used for council tax purposes. There is broad agreement on the need for council tax reform, but views differ on how council tax should be reformed. The Scottish Government and COSLA have announced a joint programme of engagement to build consensus around the long-term council tax reform. A re-evaluation exercise might look different depending on the form that the reform ultimately takes. Yes.
I'm grateful to the Minister for taking the intervention. I would highlight that my amendments do not specify exactly how the revaluation exercise should take place, with two exceptions. One, it sets a deadline, 1st of April 2029, and the second is that duty on ministers to consider appropriate transitional reliefs, because I agree there is a wider debate here. But everyone involved in this debate agrees that we cannot use 1991 valuations for the basis of any substantive reform or replacement. No reform process can move forward without revaluation taking place first. Why has the Scottish Government never put forward a revaluation proposal to Parliament, never mind simply moved ahead with a revaluation exercise?
I appreciate the point Mr Greer saying. I can't speak for previous decisions made by previous ministers or previous First Ministers in that regard. I think I'd said our approach is to ensure that the future changes, as I mentioned before, are informed by robust data, expert analysis and wide public consultation. So I would ask them not to press these amendments.
Take further intervention.
Yep.
I absolutely agree with the Minister that future decisions on reform should be on the basis of robust data. We don't have robust data. We've got valuations from before I was born and most people paying the wrong rate of this tax. Surely the only way to get that robust data is a revaluation exercise. So I'm still left confused by the government's rationale for opposing it. I understand the political challenges that other members have implied, and if that's the case for the government as well, I'd welcome if the government could be honest about that. But the Minister has just said that we require robust data to move forward with this process. That's all this amendment proposes. I'm not proposing to replace the council tax through amendments to this bill. I'm just proposing that we collect data that's accurate to the century that we're in.
I think in terms of that, one of the key things I mentioned earlier on in the speaking notes obviously was that programme of engagement with the Scottish Government and COSLA, and I think that's the best way to proceed with that in terms of that. I appreciate the points that Mr Greer is saying, but I think in terms of the engagement that's been announced by the Scottish Government and COSLA, I think that these are the issues that can be picked up in that programme. Yeah,
Thank you, Minister. On the point of consultation, engagement and listening exercise, the Minister agreed that that has happened before, and that the most substantive exercise actually took place a decade ago in 2015. And it's a perplexing argument that further consultation is required on an issue as specific as revaluation when everyone agrees that 1991 values are inappropriate and revaluation is required. I'm wondering what the Minister's expectation is of this consultation exercise versus the myriad of other consultation exercises that have all said the same thing, that we cannot use 34-year-old values for a modern council tax system.
I've understood, obviously, the comments that have come forward. I can't, obviously, in terms of speak for previous decisions that were made in terms of this. The Welsh Government also consulted on the issue in 2022, and I think they're talking around about bringing in, the revaluation is planned until 2028. So I think there's a period of work that needs to be done in terms of that. I think the points that I've raised are valuable points, but I think, as I said, the Scottish Government and COSLA have announced that programme to engage and build consensus around about that particular point. I'd like to move on now. Amendment 514, name Ross Greer. It would also require a review of the scale and impact of council tax arrear. Council tax is a local tax, and responsibility for the collection and enforcement of arrears sits rightly with local authorities. Councils have the tools they need to manage arrears, including discretion to write off debts. In addition, support for financially vulnerable people continues to be provided through the Council Tax Reduction Scheme, which offers benefits to 460,000 households across Scotland, with an average saving of £850 per year. The Scottish Government will continue to work with local authorities to explore the best ways to deal with such debt. I would therefore ask members not to press Amendment 542. Amendment 543, in the name of Ross Greer, would require a review of the impact of joint and several liability for council tax and arrears in relation to individuals experiencing domestic abuse, with a report to be relayed before Parliament within 6 months of file assent. Joint and several liability is a long-standing feature of council tax collection. It allows local authorities to recover the full amount owed by any liable individual, which helps to ensure local services are funded effectively. However, this can also present difficulties, particularly where domestic abuse is involved. These are often complex cases. A review would be an opportunity to shed further light on how joint and several liability operates in practice for those affected by abuse, and crucially could help to inform guidance for best practice that might assist local authorities in navigating these situations more effectively. I therefore support 543, although I might need to seek to adjust the timescale at stage 3. I thank Ross Greer for bringing this issue forward. Amendment 132 in the name of Men Gallagher seeks to apply the additional dwelling supplement to the purchase of 3 or more dwellings rather than the second homes. This departs from the stated policy intent of the additional dwelling supplement and has the potential to have a significant negative impact on revenues. I cannot support this amendment and would ask the member not to press it. Amendment. Yes.
Given the IFS has raised concerns about a strategy and the government's strategy for tax, can the Minister expand on what that strategy would be, when we'll expect to see a full strategy on taxation in Scotland, and how this is going to apply to the housing sector, which we're discussing today?
I can't talk for government in terms of the tax policy. I mentioned about the LPTT and review in terms of that particular point. Amendment 224 in the name of Rachel Hamilton seeks to repeal the additional dwelling supplement entirely. This is at odds with the policy intent of supporting opportunities for first-time buyers and homeowners, and this is likely to have a significantly negative revenue impact. I would therefore ask the member not to press this amendment. Amendment 225 in the name of Rachel Hamilton seeks to exempt properties from additional dwelling supplement in cases where a buyer intends to renovate the property to bring it into habitable state. We consider this amendment unnecessary on the basis that properties generally unsuitable for use, such as dwellings that are deemed non-residential, and as such the ADS does not apply to their purchase. If the intention is to, I'll just finish the point. If the intention is to exempt purchases of otherwise habitable properties, then the property will be correctly treated as a dwelling for ADS purposes. In such cases, the current ADS repayment arrangements are considered sufficient. I would therefore ask the member not to press this amendment.
I'm sure that the Minister will be aware from his own constituency mailbag that there are constituents who want to buy properties but are discouraged because they are in a state of disrepair and are then concerned that they will be liable for ADS. And all this amendment does is give that exemption from the time of purchase and up to 12 months to allow the individual to bring that back into repair and obviously allow us to have more housing stock in a housing crisis?
I think the evidence from that, there's no real evidence on that particular point. I think in terms of the properties that are unsuitable for use and deemed non-residential, an EDS doesn't apply to that. Now, and again, I think if there are individual cases that the member relates to, would be happy to engage in that particular point. But there's no real evidence that it operates on a much broader basis in terms of that. Amendment 255, in the name of Ariane Burgess, seeks to exempt registered housing cooperatives from the ADS, while Amendment 492 in her name seeks to wholly exempt all transactions by cooperatives from LBTT. Currently existing LBTT arrangements provide relief to those cooperatives who are registered as social landlord with the Scottish Housing Regulator or those who operate as registered charities. The Cooperative and Community Benefit Act requirements referred to in these amendments do not act to restrict cooperatives incorporated in this Act to purchase affordable housing only. So again, in our view, this represents a risk to revenue and a legislative approach may not wholly align with our affordable housing ambitions. Further, the exemption proposed by Amendment 492 would mean that the transactions do not have to be notified to Revenue Scotland, which presents a clear compliance and avoidance risk. We would propose that we consider these challenges fully as part of the LBTT review. I would ask the member not to press these amendments. I now turn on to the other amendments in the name of Ross Greer. Amendments 465 and 467 seek to amend sections 46 and 47 of the LBTT Act, which relate to open-ended investment companies and residential property holding companies respectively. These amendments require that legislation must be made in respect of these entities rather than may be made, as reflected in the existing legislation. It is our view that these amendments are unnecessary and that, should regulations be required, the current wording is sufficient. Happy to engage with the member on that particular point.
Intervention on that point?
Yes.
Very grateful. And I recognise these amendments are not required. Ministers currently have that regulation-making power. But it has been 12 years since Parliament gave ministers that power and they've not applied it. So could the minister just clarify what the Scottish Government's position is as of today in regards to why residential property holding companies in particular, an infamous tax avoidance vehicle, should be exempt from LBTT?
In terms of one of the things, I think the regulations have been used in that particular regard, but I'm happy to engage further on that particular point that you're making, Mr Greer, on that. Amendment 466 seeks to remove the exemption from LBTT for the purchase of military headquarters and barracks by overseas visiting forces. At introduction, this relief was considered necessary as a consequence of UK international treaty obligations and NATO agreements. On the basis of defence and international relations reservations under the Scotland Act, the removal of this exemption is outside parliamentary competence. I would therefore ask the member not to press this amendment. Amendment 468 proposes the introduction of an exemption from the EDS where a taxpayer purchases a property on behalf of an individual who is disabled and not capable of assuming the responsibilities of home ownership. We are sympathetic to those buyers who find themselves in difficult and challenging circumstances. This proposal, however, attracts significant legislative and administrative complexities, including considerations in the sharing of sensitive personal and medical information of a third party who is not connected to the legal substance of the transaction in order to ensure own users would be generally entitled to this relief from it. There are complex equality issues that would need to be addressed to ensure that the relief is designed fairly. This requires time for consultation and policy analysis. We are proposing...
Sorry, I think I should let him finish and then come in.
To assess this particular issue as part of the LBTT review, allowing us to the necessary time to fully evaluate these challenges, engage in meaningful consultation and work with Revenue Scotland to ensure compliance and avoidance sensitivities have been considered in full. I would therefore ask the member not to press this amendment this time.
Grateful for the Minister bringing him in at this point, and I understand and appreciate all of the technical issues that you mentioned, particularly in relation to data sharing and privacy. But could I just clarify, if the Government's position is one of agreement that ADS should not be applied in the circumstances I've outlined where somebody's buying a home on behalf of a disabled individual who can live there but can't be the property owner, if the Government agrees with that principle, and this is about either through regulation or at stage 3 bringing forward something to enable it, I would be happy not to press at this stage, but I'm just looking for, given the discussions we've had earlier, absolute clarity that the Government agrees with that policy objective and would work with me to achieve it through another means.
I'm happy to engage with the member at that particular point. I think in terms of the complex issues that are there, I think that's something we need to work with Revenue Scotland in that particular point. So,
intervention.
Yes.
I'm sorry, Minister, but I'm not clear on your position here. I agree with you that this is a complex area. I agree on the need to work with Revenue Scotland, etc. I'm asking if the Scottish Government agrees with the policy objective that ADS should not be applied in these circumstances. If it agrees with the objective and will work with me on a different means of achieving it, I won't press. But if the Minister simply responds again to say that these issues are complex and require further consideration, I will press it, because I'm just looking, I'm genuinely not trying to be difficult here, I'm just looking for clarity on the Scottish Government's position on the policy objective.
Particular point, Mr Greer, I can't give the commitment at that stage until we have these discussions with Revenue Scotland.
Right.
In terms of, I appreciate you may want to press that amendment or not. Amendment 469 introduces an enabling power which would allow Scottish ministers to apply different ADS rates for different purposes, such as the number of properties already held by a taxpayer. Amendment 493 likewise introduces enabling power which would allow a different ADS rate to apply to companies purchasing residential properties in Scotland. Amendment 544 seeks to impose an additional amount surcharge on properties in rent control areas unless the Scottish ministers disapply the surcharge for any such area. Decisions on the rates and bans for additional dwelling supplement and the land and building transaction tax are taken centrally as part of the Scottish budget process. Any new surcharge would increase administrative complexity and might reduce revenues as a result of efforts to avoid the surge charge. Amendment 545 seeks to allow Scottish ministers to set a specific separate rate of ADS to property transactions in national parks, designated as such under the National Parks Scotland Act 2000. Members will be aware that the ADS rate is set at a flat rate of 8%, in addition to the core residential rates of LBTT, and its chargeable consistently across all types of relevant transactions. Amendments 469, 493, 544 and 545 would allow for a significant divergence from existing arrangements, a long-standing policy, and would thus require thorough consultation to ensure such amendments have intended effect. I would ask the member not to press these amendments. Amendment 546 enables Scottish ministers to set a specific separate rate of ADS to property transactions made by individuals not ordinary resident in Scotland, where the property purchased is not intended to be that individual's only or main residence. Consultation and engagement with Revenue Scotland would be essential here, allowing us to fully consider potential administrative challenges and compliance risks, including access to necessary data and inherent complexity of establishing an ordinary residence for tax purposes. I would therefore ask the member not to press this amendment. Amendment 547 requires Scottish ministers to introduce for the 26-27 year an additional residential LBTT for properties with a chargeable consideration of £1 million or more. Members will be aware that decisions on the rates and bans of LBTT are taken as part of the Scottish budget process. Further, given the small number of transactions which take place at this price point, the proposal would likely generate limited additional revenue. I would therefore ask the member not to press this amendment. Amendments 193 and 194 would remove the requirement for local authority to obtain ministerial consent to transfer amounts from the General Fund to the Housing Revenue account to support social housing provisions, whilst ensuring that any transactions are recorded in the Housing Revenue account. I support these amendments as they align with the Verity House Agreement in giving local authorities greater financial autonomy over how to fund social housing. Amendments 459, 460 and 461 would require the Scottish ministers to levy a non-domestic rate supplement on short-term lets suitable for providing housing on a temporary or permanent basis, or require the Scottish ministers to remove reliefs. Amendment 459 would require ministers to levy a non-domestic rate, higher non-domestic rate on these types of property, and would also prevent the amount of rate charged from being remitted or reduced. These types of property would not be able to receive any such relief, such as Small Business Bonus Scheme relief, Business Growth Accelerator relief, Fresh Start relief, or local reliefs the Council may wish to offer. Amendment 460 would only require ministers to levy a non-domestic rate supplement on these properties. Amendment 461 would only require ministers to provide the rates changed or not remitted or reduced. I understand Mr Greer's concerns, particularly those around about the contribution of self-catering accommodation to local taxes. However, the classification of such accommodation has already been significantly tightened in recent years to prevent avoidance by second homes, following a recommendation from the independent Barclay review of non-domestic rates. Since April 2022, owners must evidence an intention to let for 140 days and actual letting for 70 days a year. Ministers already have the powers to adjust reliefs and apply supplements, and these amendments would constrain that flexibility. For instance, ministers can no longer choose to provide transitional leave to the self-catering accommodation sector following a revaluation, no matter how high the increases in native value may be, nor could they offer relief to support the sector during a pandemic anymore. Whilst I accept that many self-creating properties receive 100% relief, and I do understand concerns about the role in the housing market, I do not believe these amendments offer a nuanced or proportionate solution. They risk being a blunt tool that cannot take into account the varied landscapes of business that operate in the sector. I'll just conclude. The scope of these amendments could also intentionally capture a wide range of property types, such as hotels, guest houses and timeshares that may not be the intended target. A more effective way forward lies in tailored local measures, such as licensing schemes already in place.
I'm grateful to the Minister. In a lot of these amendments, obviously, my intention here is to reduce the number of properties that are second-hand holiday homes or that are used as short-term lets. And specifically what I'm looking at is those that would be appropriate as permanent accommodation. I understand that government obviously doesn't support these amendments. Could I, just for clarity though, check, does the Scottish Government believe that the current proportion of properties that are being used as second-hand holiday homes and short-term lets is an appropriate balance, i.e. the examples that have been mentioned about Loch Ranza on Arran, Braemar, Loch Lomond and Trossachs National Park? Is that proportionate, or does the Scottish Government believe that further action is required to rebalance the housing sector in those areas? And if so, what alternative option is there?
I think there are a number of points to make on that one. And again, coming to the short-term lets, I think there has to be the balance, and I appreciate the point that Rachel Hamilton made in that. There has to be a balance in terms of the housing provision that's required, but also in terms of the tourism it's there. I think that is varied across Scotland. In my experience, that's varied for Scotland, and I think the best way, as I said, mentioned in the last line of that, is bringing forward tailored local measures, and I mentioned such as licence schemes. The Scottish Government also had the ability in terms of looking at short-term lets control areas, which is up to each individual local authority in terms of that, and I think that's the best way to take them forward in terms of what we're supporting here, in terms of local authorities knowing their own individual circumstances. Noting the next evaluation is on 1st of April 2026, I'm open to discussing with the member how the targeting of the small business bonus scheme could be improved. I would, of course, want to ensure that business and other stakeholders can comment on any specific changes, proposals for change, including via the consultative non-domestic rate subgroup set up under the New Deal for Business. Amendment 550 would modify a sunset provision so a power to establish an infrastructure levy in Section 54 of the Planning Scotland Act 2019 will not lapse in July 2026, insofar it may be exercised in relation to housing developments. The Scottish Government consulted last year on introducing an infrastructure levy. The responses made clear that neither the development industry nor local government strongly supported it. There were widespread concerns about the complexity and uncertainty that levy could introduce and the limited funds it would likely raise. We therefore decided to stop that work and allow the powers to lapse. Retaining the power to establish an infrastructure levy in relation to housing developments would create additional uncertainty in the market, potentially limiting investment and the provision of much needed housing. I would therefore ask the member not to press this amendment. In summary, I support amendments 191, 193, 194 and 543 in the name of Ross Greer, but oppose other amendments in the group. If any of these amendments are pressed, I would urge members of the committee not to support them. Thank you, Convener.
Thank you. Ross Greer to wind up, press or withdraw Amendment 519.
Thank you, Convener. I'll just briefly address some of the points that have been raised in the debate, but given the temperature in the room and how time has gone on, I won't catch everything, which I hope members will appreciate. But just on LBTT in the first instance, I've got to say I am recognising that I have really maximised the capacity for potential for amendments with the scope of this bill, and that most of what I'm moving here I think would be more appropriate in a dedicated tax bill, but that the Scottish Government does not bring forward such dedicated tax bills, so there's no finance bill associated with the budget each year, for example, which is normal in a number of other parliaments. So given that, I've taken this opportunity to try and understand better the Scottish Government's position on a number of these issues. I think it's frustrating for me, and not for the first time for this group, that very often the Minister's position has been that he can't speak for the Government more widely. Given that I notified the Government of the vast majority of these amendments in January, I would have thought that a position and the Minister would have been able to come here with more information. So, for example, I don't think it's satisfactory to use the LBTT review to avoid addressing the fact that Scottish Government policy, as it currently stands, is not to apply LBTT to 2 particular types of company, one of which is infamous for tax avoidance. These are regulations that the government has had since 2012. I think it sounded like the Minister said in regard to one of them, the regulations had been brought forward. That's not Spice's understanding or mine. And nonetheless, the reality is we've got a company type infamous for tax avoidance that the Scottish Government, as it stands, has specifically exempted from paying this tax, but can't justify why, despite me having raised this issue months ago. So it is frustrating that the Minister is not, I think, as prepared as would be appropriate to discuss these issues. On council tax revaluation, I hear what members are saying. So if you hear members saying that we need more time to consider this, I would suggest we have had 34 years and we have spent most of the last 34 years discussing this in one way, shape or form. I've heard suggestions that we should do it next session. I would highlight that we said that last session, particularly off the back of the 2015 review group and the comprehensive piece of work that they did that I think is still largely sitting on action. In fact, to the point where when it came up at a recent meeting of Parliament's Finance Committee, I discovered that the domain name for the website set up by the government for that group had expired, and therefore all the documents had been lost, and the government needed to use the Wayback Machine, the Internet Archive, to recover them, which I think was a poor example of document handling, but there you go. There's been a suggestion that we need to do more work. Well, that 2015 group did the vast majority of the work for us on this. It was cross-party, but led by the government, included other stakeholders. It's not the only group to have done this work. There's been a huge amount done outside of the Parliament by a great many people who are frustrated at the lack of progress in here. There's been suggestions to deal with this in a separate bill. I will take that as Mark Griffin's encouragement for me to, if I'm fortunate enough to be re-elected, immediately announce my intentions to bring forward such a bill next session, and that he would be supportive of that. I've heard a suggestion that, I think it was particularly from the Minister, that we haven't decided yet how revaluation should work. Well, I mean, that's absolutely fine, because my amendments don't specify how the revaluation process should take place. They just specify the deadline and that there should be consideration for reliefs. But fundamentally, the issue that I think members have been quite candid about is that this is often regarded as an issue that is just too difficult. But the longer that we defer it because of the difficulty, the more difficult it becomes. And we are now at that point where, as I said, and others have said, most people are paying the wrong rate of tax. And it's absurd. And we all agree it's absurd. And we all have the opportunity to do something about that. Putting aside the various positions that we would take on the more substantial issue of reform and potential replacement of the council tax, this is just updating the role to make sure it's accurate, which is also a prerequisite of any substantive discussion about reform and replacement. No one is suggesting that if we replace the council tax, we would stick with 1991 valuations for whatever we replace it with. So I am frustrated on that point, particularly because, as I said, this is, so far as I'm aware, the first time Parliament will have the opportunity to vote on revaluation. Now, moving on briefly to the various proposals I've put forward around the additional dwelling supplement and non-domestic rates, the kind of collective efforts I've put forward to address what I see as the imbalance in relation to second and holiday home ownership and short-term lets relative to permanent housing. Rachel Hamilton said that the biggest impact here would be for small landlords, not large investors, and that's who we're really talking about. We are talking about landlords, but who I'm really talking about are the people who cannot get a home, because in communities like the ones that I represent, particularly on Arran and up the west side of Loch Lomond, because there are so many people who have seen houses in these areas as an investment opportunity and who have become a small landlord, perhaps to provide a pension or as an income during their working life. But that has come at the cost of people being unable to live in the communities that they grew up in. And there's a perfectly legitimate argument that says we have not built enough affordable and social housing for decades. Absolutely we've not. I would suggest that there is very little value in building more affordable housing if that housing is then purchased by those who are using it as an investment opportunity. There's no point in building more affordable housing in a community like Luss in Loch Lomond if that is going to be bought up by those who want to use it as a holiday home or to rent it out through Airbnb. That does not solve the housing crisis in those issues, in those areas. So we do need to combine the construction of far more homes with measures to make sure those homes go to the people who actually need somewhere to live. I was particularly confused by what the Minister said in relation to a lot of these, though, because I think he contradicted himself. The Minister says that there needs to be balance and that the situation is varied across Scotland. Of course it is. It's a significant divergence across the country. Rachel Hamilton pointed out that nationally we're talking about less than 1% of properties, but as I mentioned in Lochranza it's 40%. There are communities in the Highlands where it is above 50%. So why oppose amendments that would give us the flexibility in the tax system to recognise that nuance? Surely, if we believe that the situation is varied across the country and that a localised approach is required, it would be appropriate for us to set a different rate for the additional dwelling supplement within a national park that is experiencing significant difficulties versus the rate that we're setting nationally and in the areas where there is not that particular challenge. So I don't quite understand the government's position here, because it's simultaneously that a blunt national approach is appropriate and that a localised approach is appropriate. But all the amendments that I've put forward that would give the government the flexibility to take a more localised approach are being opposed. So I understand if the government was simply opposed in principle to what I'm proposing, but the argument they've put forward is inherently contradictory. I'm particularly disappointed by the government's position on 468, not just because this is an issue that I raised with the Minister 4 months ago, but it's an issue that I've been raising with the government for coming up on a couple of years now, and no one has ever disagreed. I think everybody agrees that the additional dwelling supplement was not intended to catch people who are buying properties on behalf of disabled relatives who can live independently but are not in a position to own it. And if the government had been in a position to agree to that policy objective and to work with me on a different way of achieving it, I would have been happy to do so. Always happy to cooperate with the government. But the lack of agreement on that point of principle is going to force me to press that amendment to a vote. 'Cause the amendment is not prescriptive. The amendment gives the government appropriate scope to work through the technical issues associated with this, particularly in relation to data sharing. These are not insurmountable or even unprecedented issues. So on that one in particular, I'll certainly be moving to a vote, because this is an issue that has affected a number of my constituents that I've been engaging with the government with for some time, that I don't think I should have needed to bring forward through this bill, but through lack of engagement from the government up to and including at this point, I am going to have to move to a vote, because I hope that Parliament will address what I see as a minor issue, but really significant for the individuals it affects, a minor issue that the Scottish Government, for reasons that I'm still not clear on, has, as of yet, failed to address itself. So I'll close there, Convener. Thank you.
Thank you. Ross Greer to press or withdraw Amendment 519.
Press, please.
Thank you. The question is that Amendment 519 be agreed. Are we all agreed? No. We're not agreed. There will be a division. All those in favour of Amendment 519? Those against? The result of the division on Amendment 519 is 1 for and 6 against. The amendment has been disagreed. I call Amendment 52 in the name of Graham Simpson, already debated with Amendment 51. Graham Simpson to move or not move?
Moved.
The question is that Amendment 52 be agreed. Are we all agreed? We are not agreed. There will be a division. Those in favour of Amendment 52? Those against? Thank you. The result of the division on Amendment 52 is 4 for and 3 against. The amendment has been agreed. The question, I call Amendment 206 in the name of Rachel Hamilton, already debated with Amendment 203. Rachel Hamilton, to move or not move? Moved. The question is that Amendment 206 be agreed. Are we all agreed? No. We're not agreed. There will be a division. All those in favour of Amendment 206? And those against? The result of the division on Amendment 206 is 4 for and 3 against. The amendment has been agreed. Call Amendment 86 in the name of Megan Gallagher, already debated with Amendment 85. Megan Gallagher, to move or not move?
Move.
The question is that Amendment 86 be agreed. Are we all agreed? No. We are not agreed. There will be a division. Those in favour of Amendment 86? Those against? The result of the division on Amendment 86 is 2 for and 5 against. The amendment has been disagreed. I call Amendment 87 in the name of Megan Gallagher, already debated with Amendment 85. Megan Gallagher, to move or not move?
Move, please.
The question is that Amendment 87 be agreed. Are we all agreed? Yes. We're not agreed. Those in favour of the amendment, 87? Those against? The result of the division on Amendment 87 is 2 for and 5 against. The amendment has been disagreed. I call Amendment 88 in the name of Megan Gallagher, already debated with Amendment 85. Megan Gallagher, to move or not move?
Move, please.
The question is that Amendment 88 be agreed. Are we all agreed? No. We're not agreed. There'll be a division. Those in favour of Amendment 88? Those against? The result of the division on Amendment 88 is 2 for and 5 against. The amendment has been disagreed. I call Amendment 89 in the name of Megan Gallagher, already debated with Amendment 85. Megan Gallagher, to move or not move?
Move, please.
The question is that Amendment 89 be agreed. Are we all agreed? No. We're not agreed. There will be a division. All those in favour of Amendment 89? Those against? The result of the division on Amendment 89 is 2 for and 5 against. The amendment has been disagreed. I call Amendment 90 in the name of Megan Gallagher, already debated with Amendment 203. Megan Gallagher, to move or not move?
Move.
The question is that Amendment 90 be agreed to. Are we all agreed? No. Okay, we're not agreed. There will be a division. All those in favour of Amendment 90? Those against? You can put your hand down now that you got it. The result of the division on Amendment 90 is 4 for, 3 against. The amendment has been agreed. I call Amendment 279 in the name of the Minister, already debated with Amendment 203. Minister, to formally move.
Formally moved.
The question is that Amendment 279 be agreed. Are we all agreed? Yes. We're all agreed. I call Amendment 91 in the name of Megan Gallagher, already debated with Amendment 85. Megan Gallagher, to move or not move?
Move, please.
The question is that Amendment 91 be agreed. Are we all agreed?
Yes.
We're not agreed. There'll be a division. All those in favour of Amendment 90?
91.
Oh, sorry, 91. Thank you. All those in favour of Amendment 91? Those against? The result of the division on Amendment 91 is 2 for and 5 against. The amendment has been disagreed. Call Amendment 142 in the name of Edward Mountain, already debated with Amendment 203. Edward Mountain, to move or not move.
Convener, I believe that I must make a declaration before talking into this committee in any shape or form. And I apologise, I was unable to attend the meeting earlier, but I was convening another parliamentary committee. I'd just like the committee to be aware that I have been a surveyor before I became a parliamentarian, letting houses under the 98, 2001 and 2014 Act. I'm also a private landlord in my own right and have been since 1989. I let houses under PRTs, no short-term lets, Mr Greer, for me, long-term lets for housing, and I also let them under licence to employees. So on the basis I've made a full declaration, Convener, I would like to move Amendment 142.
The question is that Amendment 142 be agreed. Are we all agreed?
Yes.
We're all agreed. I call Amendment 143 in the name of Edward Mountain, already debated with Amendment 203.
In the hope for a run
Edward
moved,
Mountain
Convener.
to move or not move.
In the hope for a run moved, Convener.
The question is that Amendment 143 be agreed. Are we all agreed? No. We are not agreed. There will be a division. All those in favour of Amendment 143? Those against? The result of the division on Amendment 143 is 4 for, 3 against. The amendment has been agreed. I call Amendment 280 in the name of the Minister, already debated with Amendment 203. Minister, to move formally.
Formally moved.
The question is that Amendment 280 be agreed. Are we all agreed? Yes. We're all agreed. I call Amendment 92 in the name of Megan Gallagher, already debated with Amendment 85. Megan Gallagher, to move or not move?
Move, please.
The question is that Amendment 92 be agreed. Are we all agreed? No. We're not agreed. There will be a division. Those in favour of Amendment 92? And those against? The result of the division on Amendment 92 is 2 for and 5 against. The amendment has been disagreed. I call Amendment 93 in the name of Megan Gallagher, already debated with Amendment 85. Megan Gallagher, to move or not move?
Move.
Question is that Amendment 93 be agreed. Are we all agreed?
Yes.
Nope. We're not agreed. There will be a division. Those in favour of Amendment 93? Those against? The result of the division on Amendment 93 is 2 for and 5 against. The amendment has been disagreed. Call Amendment 144 in the name of Maggie Chapman, already debated with Amendment 203. Maggie Chapman, to move or not move?
Moved.
The question is that Amendment 144 be agreed. Are we all agreed?
Yes.
We're not agreed. There will be a division. Those in favour of Amendment 144? Those against? The result of the division on Amendment 144 is 4 for and 3 against. The amendment has been agreed. I call Amendment 145 in the name of Maggie Chapman, already debated with Amendment 203. Maggie Chapman, to move or not move?
Moved.
The question is that Amendment 145 be agreed. Are we all agreed?
Yes.
We're all agreed.
No.
Oh, no, we're not agreed. Could have shout louder. We're not agreed. There will be a division. Those in favour of Amendment 145. Confused here. And those against? The result of the division on Amendment 145 is 4 for and 3 against. The amendment has been agreed. I call Amendment 146 in the name of Maggie Chapman, already debated with Amendment 203. Maggie Chapman, to move or not move?
Moved.
The question is that Amendment 146 be agreed. Are we all agreed? Yes. Yeah. We are not agreed. There will be a division. Those in favour of Amendment 146? And against? The result of the division on Amendment 146 is 4 for and 3 against. The amendment has been agreed. I call Amendment 53 in the name of Graham Simpson, already debated with Amendment 51. Graham Simpson, to move or not move?
Moved.
The question is that Amendment 53 be agreed. Are we all agreed? No. We are not agreed. There will be a division. Those in favour of Amendment 53? Those against? The result of the division on Amendment 53 is 4 for and 3 against. The amendment has been agreed. And at this point, I would like to give my thanks to the Minister and your officials, and we're going to conclude our meeting today. Next week's meeting will continue stage 2 of consideration of the Housing Scotland Bill. We will begin with the groupings rent control areas amount of rent cap at our next meeting. And I now close the meeting.